There are teachers coming within the fold of teachers appointed under the Operation Blackboard, and more particularly those teachers who were appointed pursuant to the creation of 7066 posts on 8/3/2021 would not be entitled to pension in terms with the Assam Service Pension Rules 1969, as well as also shall not be entitled to join the fund in terms with the General Provident Fund Assam Service close Rules 1937. It was also categorically held by this court that these teachers would be governed by the new pension scheme applicable to the state government employees of corresponding rank. It was further observed in the said judgment that the teachers coming within the category of within the category of teachers appointed under the Operation Blackboard, and more particularly those teachers who were appointed pursuant to creation of 7066 posts on 8/3/2021 would be entitled to the benefit of retirement gratuity and death gratuity on the same terms and conditions as are applicable to the employees governed by the Assam Service Pension Rules 1969 in view of the office memorandum dated 1/2/2021. Taking into account the said judgment dated 31/3/2023, this court is of the opinion that the said judgment duly applies to the facts of the instant case. And consequently, this court therefore disposes of this writ petition, holding inter alia that the petitioners herein would not be entitled to pension in terms with the Assam Service Pension Rules 1969, as well as also would not be entitled to join the fund in terms with the General Provident Fund Assam Service close Rules 1937. The petitioners herein would be governed by the new pension scheme applicable to the state government employees of corresponding rank. Further to that, the petitioners herein would also be entitled to the benefit of retirement gratuity and death gratuity on the same terms and conditions as are applicable to employees covered by the Assam Service Pension Rules 1969 in view of the office memorandum dated 1/2/2021. Accordingly, the petition stands disposed.
Delhi is at no one promotion.
Yes, nobody is there.
At number one
is there. You correct for Yes, who is appearing? Mr. Das, that case I've disposed it of. Yeah. He'll be only entitled to the retirement and gratuity. Yes, PhD. No PhD. Problem is with the PhD. Yes, anybody? Hmm. We have it after vacation, listed after vacation. None appears on behalf of the petitioner on call. Mr. Arkitaluk appears on behalf of the accountant general. Taking into account that none has appeared on behalf of the petitioner, let the matter be listed immediately after the Bihu vacation. It is made clear if the petitioner is not represented on the next occasion, the matter shall be dismissed for non-prosecution.
Number 2.
Yes, Mr. Yeah.
May I please, your lordship?
Yes,
Lord,
what is your prayer?
My lord, the prayer for my lord is a challenge to a transfer order. My lord.
Oh, transfer.
My
To
lord,
me, the transfer. 1 year back transfer, why you are challenging
my
now?
lord, I have repeated approach, my lord, before the respondents, my lord. But my lord, that has not yielded any result, my lord. And finding no alternative, now I have to take shelter before my lordship. My lord.
Understood, but after 1 year.
So, my lord, what has happened, my lord? Immediately after my 5 months of initial, my lord, appointment, suddenly, my lord, in an arbitrary manner, this transfer has been effected. My lord, as a compulsion, my lord, I have to go and join, my lord, as a my lord, law-abiding, my lord, officer of the department, my lord. But, my lord, may kindly, if my lord may be pleased to travel through the various annexures, my lord, which I have projected in the petition, my lord, the manner in which I had been transferred, my lord, is a case, my lord, wherein my lordship may be pleased to examine, my lord.
Why?
My lord,
Why should this court examine that?
my lord, if my lord may be pleased to take up the transfer order, my lord, is there page, my lord, 43, my lord.
40?
43, my lord, annex of 5.
Yes.
My lord. May I read over, my lord? The operative part in the interest of public service, Dr. So medical social worker, Silchar Medical College and Hospital, is hereby transferred and posted as the medical social worker, Fakhruddin Ali Ahmed Medical College and Hospital, Vice so Ali Ahmed Medical College and Hospital transferred. Is hereby released from the post, my lord, on the day of my, my lord, transfer with
So
this
from
order, my lord.
Silchar, you have been sent to Borpeta?
Borpeta, my lord.
Very well.
Now, my lord, the policy of the transfer is very clear, my lord. I have also annexed the operative, my lord, office memorandum. My lord may be pleased to find at page 61.
Ah.
My lord, it says that the policies of the transfer of the government officials, as per the state government standing office memorandum number.
This has already changed. This is now 2 years. Anyways,
my lord,
but when were you there in Silchar?
My lord, yes, my lord, my initial appointment, my lord, may be pleased to find. It is a press appointment, my lord, responding to advertisement at Annexure 1, page 27, my lord. I was appointed at page, my lord, 31. Annexure 2 is my appointment order dated 4/9/2021. My lord. Page 31, yes, my lord. Page 31 is my appointment and my joining following the next annexure, my lord. Then, my lord, I was continued for 5 years, my lord. My lord may be pleased to find that the
you are continued to
till, my lord, 31/02/2022, my lord. Just for a period of 6 months, my lord. Now they have
this appointment order is of 4th of September 2021.
When, no, my lord, this
Annexure 2, page 31.
yes, my lord.
And then you have been, this transfer order was given on 31st of March 2022.
My lord, from September 21 to March 22, my lord.
Yes.
From September, my lord, September, October, November, December, my lord. 3 months, and here is, my lord, 3 months, 6 months nearly, my lord.
Then,
my lord, suddenly this transfer order has been effected.
Then,
Yes, my lord.
and you are coming after 1 year.
No, my lord. Yes, there is a my lord, reason.
No.
My lord.
Which means how much has gone? 1 year, 6 months have gone. Why should this court
No, my
interfere
lord,
now?
from the date of my transfer, my lord. From the date of my transfer, my lord, it is from 31st of March 2022. my
Yeah,
lord.
on
Now,
3rd of April.
yes, my lord. Now it is 1 year. It is correct, my lord. But what I have done, my lord, during this period, I have, my lord, repeatedly approaches the respondents, my lord.
No. But
Why?
why should this court at all interfere in these type of matters now? You have a duly accepted, gone there.
No, my
It's
lord,
okay.
yes.
And immediately you have come before this court, the court would have thought about it. Why should this court look into it today? And as of now, it is 2 years, no longer 3 years.
my lord.
You were given or you were appointed on probation.
No, my lord. This same manner, everybody has been appointed. my lord.
Understood, but you were appointed on probation.
Probation,
You
my
were
lord.
given out there. So 6 months you here to be there, and thereafter we'll thinking about it, whether to keep you here or there or whatever may be. Why should this court interfere after 1 year?
Because, my lord, the respondent has not responded to my request, my lord.
So,
That's why, my lord. My lord, may I kindly see the repeated representations we have made. My lord, the series of representations.
no,
my lord,
Mr. Bhuya,
My
this
lord.
court is not satisfied. When you dismiss it, do you withdraw?
My lord, may I kindly appreciate.
No, Mr. Bhuya. Sorry. What do you want? Dismiss or withdraw?
My lord, she is a lady, my lord, having 2 kids, my lord.
You knew it at the time of appointment. You may be put from here
But, my
to
lord,
there.
there are other issues are there, my lord. The reservation issues has also been violated, my lord.
What?
The post in which I was appointed, my lord, was a general category, my lord. And the person, my lord, who has been appointed in the Borpeta, Fakulty Nalia Medical College is from the reserve category. Now, my lord, a general category has been exchanged with the reserve category, my lord. That is also not permissible, my lord.
Can you raise that issue?
Yes, my lord, because I am from the general category, my lord. I have been replaced with the reserve category,
So?
my lord. That the roster point has been violated, my lord.
The roster point is violated. It is for those people to agitate. How are you going to? Why are you going to agitate on that aspect of the matter?
Because, my lord, because, my lord, I have been replaced with a my lord, reserve category. The post which has been earmarked for me, my lord, was for the general category. Now I have been replaced with
If a reserve category candidate comes up and says that, look here,
my lord,
this person has been given out here and thereby taking my place,
my lord.
and I should have been there. It's a different aspect. But who are you?
Because, my lord, I have been replaced,
Lord, Mr. Which one? Withdraw, dismissed.
my lord, with the liberty. I may be
No
allowed to
liberty.
withdraw, my
No
lord.
liberty. What liberty? Liberty for you. Liberty is only to pursue as regards the representation, nothing more than that.
Then, my lord,
I don't give any
then, my
liberty
lord,
for the purpose. It means there another change in the bench, then you come
no.
again.
That is, my lord, that is
That
not
is the
my.
reason why this liberty is asked
Then,
for.
my lord may be dispose of, my lord, with the direction to consider my representation at least, my lord. They can come up with disposal of the representation, considering the, my lord,
Let us see your representation.
my lord. First one, my lord, is page 45, my lord. Though it is addressed to the chief minister, my lord, it has been.
Why you are making it to the chief minister? Chief minister is the
No,
head.
my lord, it has been forwarded to the commissioner at page 48.
But why are you asking that to meet the chief minister? As I could see from one document out
Yes,
here,
yes,
you
yes.
are asking his. Where is that
My lord,
document?
some layman people thought that, my lord, that
Not layman. Layman is not there because every time here on 13th of February 2023, yes, from so and so, as the matter for seeking appointment with the chief minister is directly related to health, hence you are advised to contact the honorable minister of health for appointment with the honorable minister for discussing.
my lord,
He's tired. After representation is being given to the chief minister.
my lord.
Then,
No, my lord, yes, my lord.
why then? If those representation, if I ask the authorities to consider, it will be asking the chief minister to
No, my
consider.
lord, that is not the issue.
Where
my
is
lord.
the representation to the office?
Then, my lord, I will make a fresh one, my lord, that may be considered, my lord. That observation may kindly be given.
That is why they are not giving any relevance out there.
No, my lord, what has happened, my lord?
Then
This
Why are you
representation-
asking the chief minister?
No, my lord, it has been forwarded to the commissioner. my
No,
lord.
no, for what forwarded, not
My lord,
forwarded. Look
may-
here,
may-
all these documents which are given,
My
all are given to all representations are given to the chief minister.
My lord,
Why?
I have, my lord, one annexure, my lord. maybe
Even
two-
after, no,
My
Mr. Bhuya, kindly appreciate.
My lord,
On 18th of February, you have been asked to give it then also to the minister concerned or the health department. Why you have not done it?
my lord, it was not properly done, my lord. My lord, I will give one opportunity, my lord, make a press, my lord, and that may be
Withdraw.
with a liberty, my lord, to approach the authorities, my lord, with a press representation. My lord,
Is
one
it that you are at always at liberty?
liberty, my lord. My lord, may kindly see.
Heard
the
Mr.
page-
A.R. Bhuya, the learned counsel appearing on behalf of the petitioner. Madam D. Bora,
Yes, Deborah, I am for 1, 2, 4, and 5.
so and so appears on behalf of the health department of the government of Assam. The learned counsel appearing on behalf of the petitioner had submitted that as in pursuance to the communication dated 18th of February 2023, there has been no representation given to the concerned minister and or the departmental head or the appointing authority. He would not like to press the instant writ petition. However, the withdrawal of the instant writ petition should not preclude the right of the petitioner to submit the representation to the authorities concerned. Taking into account the same, the instant petition stands dismissed on withdrawal. However, the dismissal of the writ petition shall not prejudice the right of the petitioner to approach the authority concerned.
my lord, and they will consider my representation.
Mr. First, this court has to be clear that you have a legitimate expectation. I don't think you have. You want that, I am not saying anything to that.
Obliged, my lord.
And number 3,
Yes, madam.
I have put your lordship, petitioner before your lordship, paying for
Direct the area salary of the petitioner
Yeah,
from
from-
so and so in so and so, which is amalgamated. Yes, why haven't you been paid for 7 years, madam?
That is the matter, madam. Why
You have no idea.
They are repeated.
You have not got your salary. Have you at all got any salary from all this time?
Yes, my lord. From
Then
the-
didn't it
from-
click in your mind that I have not got the salary from 2015? Why so? And you have opened your eyes only in the month of March or February. When did the client come to you?
No, my lord, actually, the thing is that after reinstated in their service, after termination, the petitioner was reinstated in her service on 2015. From 2015 to 2022,
When were reinstated?
reinstated on 2015, my lord, that is annexure. Annexure,
Oh, this
Well-
one, page annexure 11, page 35.
no, annexure 12, page 36, my lord.
In pursuance to the order dated so and so and so and so. Okay, so you were reinstated on 16th October. Now from then you have not got your salary.
Yes, my lord. Up to 2022 on 14,
Now you have got,
that is the reason, my lord, on,
so from 15/7/2022 you have got or you have retired?
no. I am appointed, adjusted in the retired vacancy on,
No, my simple question is, after 14/7/2022, have you got your salary?
yes, my lord, yes.
Yes.
regular
So
salary
after
I have,
you are still working?
still working.
Yes, Mr. Chaudhary.
Lordship,
Why
I have
haven't
to-
you paid?
Lordship, the reason, Lordship, I have to take in.
Very well. Any interest also?
Lordship, I'll take the insurance.
Yes. Heard Mrs. A. Budarburu, the learned counsel appearing on behalf of the petitioner. And Mr. P.K. Bora appears on behalf of the respondent number 1, 2, 3.
Chief Secretary Finance.
Huh?
Lordship, Mr. Kalyani.
1,
One and two, my lord.
and Mr. A. Solia appears for respondent number 3. Mr. B. Chaudhary appears for respondent number 4, 5, and 6. Issue notice making it returnable by, we get the instructions on 8th of May.
Yes.
On issue notice making it returnable on 8th of May 2023. As the respondents are duly represented, extra copies of the petition be served by today 10 by 12 by 12th of April 2023. The case of the petitioner herein is that the petitioner was initially terminated
Terminated. That is annexure 10.
terminated
34.
by an order dated 30
25 June.
was terminated by an order dated 23/6/2009 by the Director of Education, Borough and Territorial Council. Subsequent thereto, by an order dated 16/10/2015, the said termination order dated 6/11/2008. 26. No, you were terminated when? The
23rd
services of Kalpana Bormon is hereby terminated from office with immediate effect for not fulfilling the following condition. It is on 23rd of June,
Yes, my lord.
Annexure 10. Now, page
Annexure
35, which order has been withdrawn?
Petition was held on 26 June. Meeting was held
Termination
on.
order dated transfer again.
We have withdrawn the termination order. I stated
So this order has not been withdrawn, 23rd of June.
that was all withdrawn, my lord, but actually thing is that a large number of people were terminated, so maybe a
I
different order was.
understood, but
Lordship in page 36, Lordship middle of the portion, first paragraph order, Lordship will find.
in pursuance thereto. In pursuance thereto,
16 October.
by an order dated 16/10/2015. The order of termination dated 23/6/2009 was withdrawn, and the services of the petitioner was regularized or reinstated in Poop Nolbari Balika LP School in the scale of pay bracket PB2 bracket close rupees 5,200 to 20,200 with grade pay of rupees 2,500 per month plus other admissible allowance as admissible under the existing government rules. The case of the petitioner is that with effect from 16th of October 2015 till 14/7/2022, the petitioner was not paid her salary. However, from 15/7/2022, the petitioner till date have been receiving the salary. It is on account of the arrears salary for the period from 16/10/2015 to 14/7/2022. The petitioner has filed the instant writ petition claiming seeking a direction upon the concerned respondent authorities for disbursing her for payment of her arrears salary. The learned counsel appearing on behalf of the BTC, Mr. B. Chaudhary, shall apprise this court on the returnable date as to why the petitioner have not been paid the arrears salary for the period from 16/11/2005 to 14/7/2022. The said council shall also apprise as to apprise that if the petitioner is entitled to, when the said amount would be paid. Pending disposal of the pending notice, the respondent authorities are given the liberty to disburse the said amount. Keep him paid.
First, item number 10 is C.
Then
item number 10 is same,
Same period,
same.
same case,
Same.
same lawyer.
Ma-
Hello, one.
Item 4.
Yes.
May I please your lordship, I am an Anganwadi worker, your lordship. My remuneration has been stopped, your lordship. That is why I am approaching for the honorable court, your lordship.
You have been given a show cause.
Your lordship,
lordship.
show cause 3 show cause, your lordship, only giving 3 days time to reply, your lordship. I have given reply to each and
Why are you
every
asking for setting aside the show cause?
lordship. There is no valid reason for making this show cause, your lordship.
So?
I have repeatedly, your
You
lordship.
write to them that there is no valid
Same
reason.
explanation, your lordship, same set of questions, your lordship. I have been-
Understood, but they wanted to give the reply. Why are you asking for setting
May
aside the
not be,
show
your
cause?
lordship, that what relief actually I
A
have got to-
showcase can only be set aside, means only be touched
Your
upon
lordship,
if it is given which is beyond jurisdiction. Is it your case that they have no jurisdiction?
Yeah, look, they have got to-
Very well. So show cause is gone. Then why you are asking for setting
Your
aside an
lordship, my
order
main
dated?
query is, your lordship, that your lordship, my salary which has been, your lordship, stop, your lordship, that may be released. My salary,
There must be some reason.
your lordship, there is, I have.
You know
given-
the government always does the. Mr. Kusami,
Yes.
I don't think you unreasonably
Yes, Lord.
withhold to the
Yes,
salary.
Your lordship.
reasons are, so many reasons are there. We
So
have
may-
the reason.
Okay, we'll issue
Your
notice.
lordship, allegation is against me is that, your lordship, that the fact is that, your lordship, the land was donated where the Anganwadi center is there. Your lordship, the land was donated by my husband. Your lordship. After that, I had been continuing in the year 2011, Anganwadi center was constructed, your lordship, by the contractor, your lordship. The construction was very poor, your lordship. After that, it's a flood prone area, your lordship. The flood was during the year, your lordship, 2017, your lordship, a massive flood occurred, your lordship. In that flood, your lordship, partially the center was damaged, your lordship. That mud gathered, your lordship. It was covered by mud and all this, your lordship. After that, I continued to, your lordship, teach in that center, your lordship. After that, in the year 2018, a storm, your lordship, a strong storm, your lordship, hurricane, your lordship, broke the center, your lordship.
Huh?
Broke the center, your lordship. That the tin sheet came under the wall, your lordship.
Why?
So
Flood.
after flood, that hurricane, your lordship.
Okay, hurricane.
That explanation I have given each and every time, your lordship.
The hurricane happens in Assam also.
No,
Lordship,
no,
that-
lordship.
How
No,
that is how
lordship, the
for the
position-
storm, your lordship.
You give us
Our
the,
allegation is that, lordship.
you are giving us the
see-
case that we are still staying in states, United States. Yes.
Yes, our allegation is that she himself destroyed Anganwadi center to sell that property to any other one, some other one, and she run that Anganwadi center in her house itself. Because when they required the land, they destroyed the entire house, and after that they sold that property to someone else. And she run the Anganwadi center in their house, in her household. That's the allegation. No satisfactory answer was given by from her side. Therefore, notice maybe you should receive. We will address all
I
these
don't know
things.
from where he got all this information, your lordship. At page 60, that maybe your lordship may be
But
looking to
Mr. Your name?
T. Ahmed, your lordship.
E. Ahmed, the learned counsel appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the
All the
respondent numbers 1,
All
2,
the
3, 4, 5, and 6. Issue notice making it returnable on 10th of May. 10th of May 2023. As Mr. Goswami appears and accepts notice on behalf of all respondents, extra copies of the writ petition be served upon him by 12th of April 2020.
Your lordship, I am still working, your lordship. The landholding certificate I have, your lordship, submitted to them, your lordship. I have also annexed, your lordship, and I hold by this, your
The
lordship.
case of the
I have not
petitioner
sold the
hearing,
land, your lordship.
Mr. I have heard you.
Yes, lordship, I am living in.
The case of the petitioner hearing is that the petitioner salary
Yes, lordship.
have been stopped from 8/11/2022.
Your lordship, from the year month October, your lordship.
October 2022. It's being aggrieved, the petitioner has approached this court. The petitioner have also sought for have also challenged the various show cause notices, which as per the petitioner is nothing but a mode employed by the respondents to harass her. The respondent shall the learned counsel for the respondent shall apprise this court on instruction as to why the petitioner's salary has been withheld from the month of October 2022.
Your Lordship, my only interim, your Lordship, and no further adverse action may be taken against me, your Lordship.
What?
Any suspension or your Lordship dismissal for serving
No, no.
without hearing me, your Lordship, without due
The pendency of this case would not be suffered.
That is not the question.
oblige.
They have at best, if they suspend it also, just for example, if they do anything also, you are not going to get the salary. They have taken some action, that is why they have not given you the salary.
Your Lordship, the fact is that your Lordship, I am undergoing and training your for departmental training, your Lordship, that will hamper.
You want to go.
Your Lordship, I am already undergoing. After this process start, I have been selected for the training. Your That may hamper your Lordship. That is why I am. That's what.
Any further action taken by the respondent shall be subject to the outcome of the.
Value.
5,
Yes, madam.
Lordship, petitioner approached before this honorable court by seeking a direction to finalize monthly superannuation pension of the husband as well as ADR pensionary benefit and monthly family pension with arrears.
What do you want? Retirement to finalize the monthly superannuation pension as well as the other retirement benefits left by the husband, deceased husband of the area and current monthly pension from the date following the death of so. When did the person die? When did your person die? The husband?
Lordship, 27, 2021.
Huh?
27, 2021.
20?
27, 2021.
27, 2021. Okay, then
Lordship, on earlier occasion, the husband of the petitioner approached this honorable court for finalize his monthly superannuation pension.
and then he died.
During the pendency of court.
And then you have withdrawn to file a fresh one, detailing everything, including everything.
Lordship, in the last case, the instructions which I have received is that they have submitted the death certificate, but the next of kin certificate has not been submitted. Now I have to get the instruction whether the next of kin certificate has been submitted.
Have you given the next of kin certificate
Lordship.
or have not met the petitioner in the meantime?
Because your Lordship have disposed of that matter on 22/2/2023.
So you must have met after 22/2/2022 till today, 3rd. Have you met the petitioner or not?
Lordship.
You have met.
Lord.
Has the next of kin certificate been submitted? Not aware of.
No, Lordship, here copy of death certificate and copy of provisional pension.
That is your Lordship, annexure 14, page 41, my learned friend is referring to. This is a letter from the Assistant Registrar of Cooperative Societies to the Registrar.
Hmm.
It has been written that with reference to the subject cited above, I have the honor to submit here with the original application dated so and so, submitted by so and so, along with the death certificate of her husband who expired on 27/2021. Now, after that, the last instructions we have received is that the next of kin certificate is not available with the authority.
Yes, madam. What is your instruction?
We will submit.
Where? Yeah.
No, Lordship, before the respondent, before the concerned respondent, office of the concerned respondent.
Before the concerned respondent, if you are there, then what is your cause of action without submitting today? If you have not submitted the next of kin, what is your cause of action for the petition? You want to confer with your senior? Better off. Because why this wouldn't this be petition be premature? You are alleging something, some illegalities being committed by the government, but without taking care of what is necessary. You'll have it after vacation. In the meantime, if you submit, now you know the next of kin certificate is not there. So you submit it and file an additional affidavit. Okay, we'll have it on. At the request of the learned counsel for the petitioner, let the matter be listed on 3rd of May. You get it that whatever you know what is to be done, and then bring it, and then you just see what it is.
Okay.
6 on that day, Mr. Butler, you just obtain the instruction.
Yes,
what
I'll
has
get the
happened.
instructions,
What
whether
are
it
you?
has been submitted or not.
Yes, Mr. Sekar.
Person to arrest the petitioner, he was suspended by order 811. The lodge will file page 37.
Then
Then he informed about his release on bail, page 38, as well as praying for granting subsistence allowance,
page 38,
page 38.
9/12/2022.
Then another representative.
When did you inform?
On 15/12/2020.
Then
Then another
for
representation was made,
revocation of the
for
suspension
revocation.
order and please be. Issue notice. No memorandum charge sheet
None.
being given.
As of now,
Mr. Naik, you obtain your instructions by.
No, Lordship, it's a different kind of case, Lordship. Lordship will say-
Understood. I'm not
No,
passing
this matter-
anything to that.
no, the issue is different, Lordship. He is not a government employee. In terms of offender's judgment, he was given the benefit of minimum of the pay. Now, for subsistence allowance, the petitioner, he has to be a government employee.
Understood. I'm not passing any order for subsistence. I'm only asking why have you suspended?
No, under rule 6(2), Lordship, if the person gets, if the person is under custody, Lordship, there is no question.
But
of
he's
me
not a government
suspending,
employee. How do you apply 6(2)?
Not Lordship. This has been done, Lordship. But it is not that just because the officer has done something wrong, law will change. Lordship. Law will not change just because the officer has done something wrong. So that is the issue.
No. Do you apply the rules of 64?
Lordship,
Non-government
the
employees also.
concerned executive engineer issued a notice.
Hmm.
That itself will not give him a right, Lordship. Lordship, where from his right to come, Lordship? Lordship will be tenders that just one line.
No, I've seen it. Not necessary. The paragraph number 22 you're
Yes,
referring to,
No, this
where
is,
there's a direction to give them the minimum of scale of pay,
not minimum. Sir.
and they should not
Lordship,
be thrown out.
They will continue till the age of 60 years, except on disciplinary ground, on the ground of criminal offenses.
But the criminal offense has not been proved.
Not yet proved, Lord.
Then how can you penalize him?
So that is the issue, Lord. Whether he is, has any right to get subsistence allowance or not. Because subsistence allowance is not applicable for him. So, but I'm submitting at this stage, Lordship. Lordship will allow me to some time to obtain instruction.
That is what I'm giving you.
But without issuing a notice. Lordship may
I'm
not-
not passing an interim now. I'm issuing notice. Why shouldn't this court issue a notice?
Lord. without.
I don't disturb the respondent counsels unless I issue notice.
No, I am submitting not, I'll definitely I will obtain instruction.
You obtain your
But
instructions
at this
with the
stage,
notice.
Lordship may not like to issue notice.
Why?
Because for issuing notice, Lordship, he will have to show his right, Lordship. Under white right, he is entitled to subsistence allowance. That is the basic law.
Doesn't he have the right to challenge the suspension order?
No, suspension order is there, Lordship.
That is what
At
he is
the same
asking
time, he
for.
is also asking for subsistence allowance.
Subsistence allowance is there, but doesn't he have a right? Are you saying that he doesn't have a right to question the suspension order? He may not be entitled to the reinstatement. That is another aspect.
No.
But are you saying that he doesn't have a right to question the suspension
No,
order?
in my humble understanding, Lordship, the authority did a mistake. The concerned executive engineer, he should not even have issued the notice also. I
No.
mean, the suspension order also.
Then, but you have done it.
Yes.
That is why he has come.
No, that is why I'm submitting. Just because the authority did something wrong, that itself will not give him a right.
Mr. Nayak, kindly don't try to change my how I function in the court.
No, I'm just.
I don't disturb I don't. If I want to issue notice, you don't want to accept, I will issue it to the chief engineer concerned. You don't want to
Your
accept, don't
Lordship order
accept
will
it.
be complied.
But I'm not concerned with all those things.
No, that is not the issue, Lordship. I'm submitting.
Sorry.
That is my submission on the Lord.
No, what? You are not here to say whether I should issue notice or not. I don't do anything without issuing notice. Even maybe if I have it tomorrow also, I'll issue notice. But this court is of the opinion that yes, he is entitled to a notice for the present.
Not.
Heard Mr. PJ Secretary, the learned counsel appearing on behalf of the petition. Are you accepting notice or not for the PWP? If not,
Yes.
we'll issue it to the government.
No, I'm accepting.
Who appears for finance?
All the responsibility.
Mr. P. Naik appears on behalf of the Public Works Department of the Government of Assam, as well as also for the Finance Department of the Government of Assam. And he accepts notice on behalf of the respondent number 1 to 5. Issue notice, making it returnable on 21st of April 2023. As Mr. PNAC accepts notice on behalf of the respondent numbers 1 to 5, extra copies of the petition be served upon him by 12th of April 2023. The case of the petitioner herein is that the petitioner is a master role. You are master role?
Right.
Is a master role employee who had completed more than 10 years of service as on 1/6/2017. And as such, the petitioner have been given the minimum of the scale of pay pursuant to the judgment of the division bench of this court in the case of State of Assam versus Upendas, writ appeal number 45/2014, dated 8/6/2017. Subsequent to a arrest in respect to ACB PS case number 53/2022 under section 7A of the Prevention of Corruption Act 1988. The petitioner was suspended by the executive engineer PWRD, Silchar and Udarbon Territorial Road Division in terms with Rule 6.2 of the Assam Service Bracket Discipline and Appeal Rules 1964. with effect from the date of his detention, that is 5/11/2022. Thereupon, on 8/12/2022, the petitioner was granted bail Will your name
Order,
Ah.
my lord, page 36.
on behalf of bail bonds are accepted by welfare. The petitioner was granted bail by the special judge Assam in ACB PS case number 53/2022. The petitioner thereupon on 15/12/2022 informed the executive engineer PWRD that he had been granted bail on 8/12/2022. Further to that, he had also stated that he be paid his subsistence allowance on the ground that he, being a low-paid employee serving as a non-regular master role worker, is facing extreme financial crisis and has to support his parents also. The petitioner thereupon, again on 9/3/2023, requested the executive engineer PWRD for revocation of the suspension order and to reinstate him. However, as neither the subsistence allowance nor the petitioner having been reinstated, the petitioner has approached this court on the ground that the suspension of the petitioner after being released, the continuation of the suspension of the petitioner after his release beyond the period of 3 months is contrary to the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India, reported in 2015 7 SCC 291. Further to that, the petitioner have also submitted that in terms with FR 53, is it FR 53, subsistence allowance? Just for the sake of. Further to that, the petitioner counsel has also submitted that the petitioner is suffering that on account of his suspension, the petitioner is suffering in as much as he has not suffering. The learned counsel appearing on behalf of the respondent, Mr. Pinak, shall obtain instruction as regards the suspension order and also as to whether the petitioner would be entitled to the subsistence allowance during this period, taking into account that the petitioner is not a is not in the service of the normal of the general government cadre.
Alright.
7,
May it
Yes.
please your lordship, before my learned from start, my lord, here the WPTBT is a necessary party. Their name is not reflected in the cause list, only GA is reflected. Welfare, plain traffic.
Oh. You have not given a copy to Mr. Ardhor?
My lord,
Have you given a copy to the Mr. Ardhor or not?
I have not ever. Who have,
We can talk to Ardhor copy.
they have given, my lord.
Have you given a copy to Mr. A. Sharma?
No, my lord.
Then these are all standing council. You have only given it to the government. Then can't help you. The learned counsel for the petitioner, Mr.
M.H. Ali.
M.
H. Ali.
H. Ali submits that as the writ petition was filed without serving copies upon the standing counsel for the respondent number 2 as well as the respondent number 3. He seeks an accommodation so that the matter can be accommodation for a few days. Taking into account the same, let the matter be listed on 10th of April 2023. In the meantime, the petitioner shall take steps, shall serve copies of the writ petition to the standing counsel for the respondent number 2 and 3.
Lordship, one also they are appearing.
Who is
The
one?
standing council of the plain traffic part.
Huh?
Standing council of
Same one.
traffic.
1 and 1 and 2 go to 1 and 3 will go. 1 and 2 and 3. No, one is Mr. Ardhor, the second is Mr. Asha.
8,
Obliged.
Ibu, ha? Samsung na ibu ipaling. Tama na. Recovery made.
My lord,
Recovery made.
recovery, my lord. I paid the payment, my lord. Because of that, my pension may not be sanctioned immediately, my lord.
You got back the amount. Or 1,28,000 you have to go get. You have paid.
My lord, I paid.
Now you have got your pension.
No, my lord.
Oh, then also.
Then also, my lord.
My goodness.
But even that,
Yes, Mr.
that amount
Goswami,
also, my lord, illegally recovered from me, my lord.
that is okay.
From since, my lord, June 2022, I'm not getting
Take the instruction also.
Huh?
Presently, I have no instruction on this. report.
Obviously, you don't have. But you have taken his money, then also not given him 1,28,683. Okay. These normally what they do is they correct it. That day I got called. We'll have it after vacation.
my lord.
And in the meantime, I give them an opportunity to correct their mistake. Heard Mr. M. Soronia, the learned counsel, appearing on behalf of the petitioner. Mr.
I am on behalf of
J.K. Goswami
1, 2, and
appears
5.
on behalf of the
1, 2,
respondent
and 5.
number 2.
Lordship, not 1, Lordship. 1 is the finance. 2
No,
and
no.
5, Lordship.
That is what I'm saying.
Yes.
2, 5, 2 and 5.
2 and 5.
Mr.
KK Medhi appearing on behalf of respondent number 4.
K.K. Medhi appears on behalf of the what 4? 3 and 4
3 and 4.
appears on behalf of the respondent number 3 and 4. Mr. A. Solia appears for respondent number 1 and 6. So issue notice making it returnable on 3rd of May 2023. As the respondents are duly represented, extra copies of the petition be served upon them by 12th of April 2023. We won't have it. We'll have it on 10th of May.
10th of May.
10th of May. The case of the petitioner herein is that the petitioner retired as the senior assistant from the office of the Deputy Commissioner Udalguri on 30/9/2020 after reaching superannuation. Thereupon, an amount of rupees 8,05,008 was sanctioned, being the provisional DCRG, and the amount of rupees 10,000 has been kept away as outstanding due if calculated by the Accountant General. At the time of retirement of the petitioner, his basic pay was rupees 44,390. Further to that, by another order dated 30/9/2020, sanction was accorded for payment of provisional pension to the petitioner at the rate of rupees 22,195, plus other allowances as admissible from time to time with effect from 1/10/2020
Right.
to 30/9/2021. Well, it should be 110,
Mile.
not mile.
But because I
It should be
retired on
110. How can it be 11?
my lord, 39/2020 I retired. So one
110/2020
mile,
to 39/2021,
one.
or till the issue of PPO by the Accountant General Assam, whichever is earlier, DA at the rate of 17%. Subsequent thereto, by the communication dated 2nd of February 2021, the Senior Accounts Officer of the Principal Accountant General AE Assam had issued a communication to the Deputy Commissioner Personnel Branch, wherein certain deficiencies were mentioned. The said deficiency, as per the said communication, was that at the time of fixation of pay under the ROP rules 1998, effective from 1/1/1996, giving pre-advance increment as weightage was found not in order, as the incumbent joined the post of the LDA on 16/7/1989, and the number of completed years of service in existing post as on 1/1/1996 is less than 9 years. Therefore, it was mentioned that the petitioner was not entitled to 3 advance increments as weightage under the ROP rules of 1998. Accordingly, the pay of the petitioner, as per the said communication, should be fixed at rupees 3,010 instead of rupees 3,070.
Mile.
Subsequent thereto, the Senior Accounts Officer of the Principal Accountant General AE Assam had issued a communication dated 30/12/2021 to the Treasury Officer Udalguri, whereby the PPO number 943611281991 bracket both are in favor of the petitioner for rupees 20,620 per month, was issued. Further to that, by another communication dated 30/12/2021, the senior accounts officer have mentioned that the entire total entitlement of the petitioner as regards the DCRG was rupees 7,47,891. But the petitioner had received the provisional pension of rupees 7,95,008. There was also mentioned that there was an overdue of rupees 2,64,000, 65,434. And the total overdue, therefore, 2,65,434. Subsequent thereto, on 6/7/2022, the petitioner was directed to deposit the amount of rupees 1,28,683 to the government exchequer through challan, being the overdrawal in pay and other allowances with effect from 1/1/1996 to 30/9/2020. Thereupon, the petitioner on 11/7/2022 had deposited the said amount of rupees 1,28,683 and submitted the said details to the authorities concerned. However, in spite of that, the petitioner have not till now got his final pension, being aggrieved by the action of the respondent authorities in making the recovery of rupees 1,28,683, as well as and what else are you challenging?
My lord, that recovery, then my lord, the whatever my lord, in 1/1/96, my lord.
No, that you have no
No,
business.
but not my mistake, my lord. They have did it, my lord. They cannot recover, my lord.
Whatever may be,
My lord.
if you are not entitled, you are not entitled.
And release the pension, my lord, regular pension. And
No, you will be only entitled to the pension, whatever may be, but that has to be, they can't make a recovery. But what they can is give you the actual one. The illegality cannot be allowed to perpetuate.
My lord, otherwise, one reason is that my junior, who was promoted to senior assistant 2016, I was promoted 2013. He's getting
Mr.
more pension than
Saronia,
me.
kindly tell me one thing. If you were wrongly given a particular increment,
Right.
then obviously that needs to be corrected. If somebody has been done with something else, it's a different thing. That cannot be a reason for giving you a parity by this court.
My lord, parity is must given to which is junior, my lord. If he is
Whatever
getting-
junior, senior, that is another case.
My lord,
That is another case that you are entitled, but are you entitled?
I'm entitled, my lord.
You are entitled at that point of
My
time.
lord, my lord,
So there shouldn't have been a reduction.
my lord, my lord. To give the parity with the juniors, that's right.
No, not on the parity. But are you entitled that were you entitled to these 3 increments?
No, my lord, definitely, one is I am entitled, right. But suppose, my lord, to give the parity to the junior, if, my lord, while fixing the, my lord, ROP new, my lord, if senior is
I am
getting
only
less, my lord, it be parity with the juniors, my lord.
no. Parity of the juniors does not. Whatever they have to do as per the ROP.
My lord.
They cannot do anything else.
My lord, there's a notification, my lord, I not able to find out the notification. There's a notification, my lord, to give the parity to the senior.
No.
In the
nothing.
scale of pay, while fixing, my lord, in the, my lord, new ROP rules, my lord.
That's all line 2. of rupees 1,28,683. As well as for a direction to the instant writ petition has been filed. So further to that, the petitioner have also challenged the communications dated 2/2/2021 as well as 6/7/2022 as illegal, arbitrary, and malafide. The petitioner have also sought for a direction to refinalize the pension of the petitioner, calculating the advance increment and to disburse forthwith, being legally entitled to maintain the parity, pay parity, the parity of pay with the junior. The respondent of the learned counsel for the respondent shall apprise this court on the next returnable date as to whether the petitioner is entitled to the reimbursement of the amount of rupees 1,28,683 in view of the judgment of the Supreme Court in the case of State of Punjab and others versus Rafiq Masih, reported in A2, as well as the office memorandum dated 14/6/2019 of the Government of Assam Finance Department. The learned counsel appearing on behalf of the respondent further shall apprise this court as regards the legality of the order dated 2/2/2021 and 6/7/2022 on the returnable date.
My lord, can it be, my lord, that provisional pension be continued, my lord? Since, my lord, July, I'm not getting, my lord. Now it's almost, my lord, 7 months.
You could wait for 9 months, wait for
My-
1 more.
My lord, maybe on the next that my lord, they fail to, my lord, give any proper instruction, my lord.
On the next day, because he will come up. You see, the main problem is that prayer. That prayer where you are asking for parity, which cannot be done. I'm telling you. If you see Rafiq Masih and all the judgments, it is clearly given. You can't. All this will be done as per, yes, there are 3 increments for that, their recovery cannot happen, but the pension has to be paid as per your own entitlement, not on the basis of. Now, this prayer is going to create the problem with you.
My lord,
And
Nine.
if I'm not there, furthermore,
my lord, that till next that, my lord, if they are reconsidered, my lord, the provisional pension. order.
Item
taking into
9,
account that as per you, he was given a higher rate. No?
Yes.
Why not pay the as per you the pension?
On that count, Lordship, I have to take this.
No. You have on. You see, he was given a higher amount.
Yes.
Provisional pension. Now you have reduced it, making it 20,000 something. Why not that be paid? Because how is he going to survive? Although he has been surviving for 9 months.
10, I will apprise all these things.
number 9,
On the next, an attempt shall be made to dispose of the petition on the next returnable date. If it is not possible, then the petitioner's prayer for interim prayer shall be considered.
Hallelujah.
Item number? Yes,
My lord,
same type.
my lord, judgment has recently come, my lord.
Huh?
Claiming,
Which
my lord,
one?
Claiming pension, my lord.
Old, new.
Not old, my lord.
You come under the stipendary.
My lord, the language of the initial appointment, my lord, reflects the same, my lord, at page 33, my lord, is our initial appointment, my lord. Subsequently, my lord, continuing in the same fashion and regularized in the year 2013. The tax collector, my lord, the Panchayat and Rural Development Department.
problem with your case is not that judgment, but that is there. But another, there's a direct judgment which is against you by Justice Hima Kohli. Oh, I'll have it. Just which
Supreme Court, my lord.
Supreme Court. Your case is State of Haryana versus Sakuntala Devi, 2008-15 HC68. How were you appointed?
My lord,
Look, is an ad hoc appointee.
ad hoc basis, my lord.
How were you appointed?
Appointed, my lord, the select list is not with me, my lord, at present. But perhaps, my lord,
Because the order does not say that there is a
Yes.
selection.
no, my lord, order does not say.
So
My lord, I will take inspection, my lord. Take that. Right. And
The
my lord,
order is
I
not,
could not control the entire judgment also, my lord, passed by my lordship, my lord. My lord, may I pray
no,
that
that is irrespective of that.
teachers, my lord.
The fact that you have not been appointed against the sanction post, how do you take care of that?
My lord, it is a substantive vacant post, my lord. Perhaps it has not been.
And
reflected.
if there is no selection, then is it possible? See, this judgment, as I was referring to,
My lord.
here it says, it is one thing to say that a person was appointed on a temporary post
My
on a regular basis.
Well.
But it is another thing to say that an appointment was ad hoc in the nature on a temporary basis.
Well.
Whereas in the former case, the appointment must be carried out in accordance with law.
My lord.
In the later, it may not be. From a perusal of the offers of appointment, as noticed here, it is evident that the appointments of the employees concerned were made for a period of 6 months or till a regular appointment was made. The very fact that the posts were to be filled up on regular basis by the competent authority clearly goes to show that the nature of appointment of the said persons was an ad hoc one.
Well.
So the moment it is an ad hoc appointment,
Well.
and you have accepted the same as per this order, this notification. You see, this is the notification by which you have been regularized.
Yes, my lord.
Well,
My lord, the
and this is against the post which were created.
yes, my lord.
Originally created and even later on.
Subsequently, it has been regularized, my lord. And
So you see, how do you that another judgment of the Supreme Court, the state of JNK versus Bandipora. The Supreme Court gives the concept of regularization, says that regularization is not a source of recruitment.
Uma Devi also says, my lord.
If it is not a source of recruitment,
My lord.
how do you go into the cadre? There
Lord,
has to be an appointment.
my lord, the
And if there is a question of appointment, then any appointment, the moment the appointment comes in 2A strikes in.
my lord, the once, my lord, the concept of regularization is there, my lord. From my limited understanding, my lord, the paragraph 53 of the Uma Devi says, my lord, that the person concerned or the incumbent, if allowed to work for more than 10 years, my lord, in a manner without the interference of this any interim order of the honorable court, my lord. Then, my lord, that person's regularization is an amount to, my lord, bringing that person at par with the other, my lord, similarly situated.
That was a
employees.
one-time measure.
One-time measure. That is correct. my
At
lord.
that point of time being taken.
My lord,
And
my lord.
53, if you see the last portion also,
Yes, sir, it
is a
cannot be,
portion
my
by
lord,
which whatever. But
Yes, sir.
thereafter, Umadevi have been explained in various judgments.
No, my lord, the cutoff date which has been given by the Umadevi's paragraph 53, my lord, is there regarding a cutoff date prior to the delivery of the judgment, my lord. If somebody is appointed, the government was directed to take as a one-time measure. Now, my lord, as a one-time measure in the state of Assam also, my lord, several persons, my lord, has been given the benefit of, my lord, this regularization, giving them the, my lord, benefit with the other as per employees who has been appointed by an other mode.
When did Umadevi come?
My lord,
When
in
did
2000
Umadevi?
2005, my lord, 2005. And
So
our
the moment Umadevi, let us assume Umadevi.
my lord,
Umadevi has come in 2005.
my lord.
The moment it has come in 2005, the judgment would be, has a paragraph 53 also categorically mentioned that the judgment is prospective.
Prospective.
So it will not have retrospective.
No, yes, my lord, because those appointments which were made, my lord, prior to coming into the judgment of
No,
Umadevi,
the
my lord.
power, the order says that
My-
they will be regularized.
Yes, yes, my lord.
The moment the regularization happens, the regularization has to be by way of an appointment,
Yes, that has been done, my lord. That has
which have been done in 2010.
No,
Then how do you take the benefit of the earlier?
No, my lord, that is the follow-up action pursuant to the debt judgment, my lord. The government has time to time carry out the follow-up action as a one-time measure, my lord. And in our case also, my lord.
Whatever the government does,
My-
yes, but the government cannot give the earlier benefit. How does the government will give you the benefit of a at a time when you were not in government service? Tell me.
No, my lord, the government service, my lord, the part, my lord, which we were not, my lord, at par, that has been regularized of late, my lord, in the year 2010.
Is it regularized from the date of the initial appointment?
The letter says, my lord, while my lord may kindly see, my lord, kindly see the our regularization order, my lord.
Page 42.
My lord.
Yes.
My lord, the order is at page 42, my lord.
Well, in the interest of public service, the
My lord.
governor is pleased to
Pleased to-
regularize the service with immediate effect,
My lord.
meaning thereby it is prospective.
Yes, my lord. And
Then-
1st June 2013, my lord.
my lord,
Before that, it was not even a substantive appointment.
my lord,
We dismiss it.
in the interest of public service, my lord, the governor of Assam is pleased to regularize the services of the following 51 numbers of different categories of ad hoc employees working under the Panchayat and Rural Development Department with designation shown against their name below with immediate effect. With immediate effect means, my lord, from the date of issuance of the order, my lord, they are being regularized with the, my lord, our initial date, taking into account our initial date of appointment, my lord.
Mr. Bhuya,
My lord.
you want to do that, I can give you one avenue. You use content.
My lord.
I dismiss it. You go to the appeal. Better off.
Then, my lord, I may given a one opportunity, my lord.
For what?
My lord may do it on immediately after vacation as a part third, my lord. As a part third, my lord.
Why should I part-heard it?
Because, my lord,
Not necessary.
then,
There is nothing to be part-heard about this, matters about this. But the thing is,
my lord,
the moment it is here, first of all, your appointment is not there.
that's what,
Whether it was an illegal appointment.
no, my lord, that's what that if there is some instruction, my lord, I am lacking, my lord. That instruction I may be allowed to obtain. One opportunity.
Okay, at the request of Mr. A.R. Bhuya, the learned counsel for the petitioner matter to send to John for 4 weeks.
My lord. Obliged.
Lordship, this petitioner pray for the aerial pension lordship from the date of retirement of the husband of the petitioner lordship, which is covered by the judgment of the division honorable division bench lordship. Which is at page number 97. Lordship.
Page number?
97, lordship. Lordship, earlier the petitioner was released the pension from the date of 4/12/18, which was decided by this honorable court. After deducting the initial 6 years from the qualifying service, 20 years lordship, the pension of claim of the pension petitioner was rejected. But idea is after this subsequent this judgment lordship, the pension of the petitioner on the page number 100 lordship, the revision bench has clarified that.
Yes, tell me the facts.
Lordship, the petitioner was a master role worker, lordship, in PW department, lordship, and he is retired on 31/5/2011, lordship. And lordship is subsequently submitted his documents for the
How
pension.
many years of service do you have?
Lordship, 20 years, lordship, important.
Okay, then,
Because lordship, the petitioner joined in 1989, lordship. Thereafter, lordship, his claim was rejected, stating that lordship, he is not qualified the 20 years of service, lordship.
because of Sanjita Roy.
Lordship, yes, lordship.
Then,
Because thereafter, lordship, the petitioner approached this honorable court.
Hmm.
And where this honorable court stated with lordship, the as already there is a judgment, lordship, granting the pension from the 4/12/18.
for
4/12/18, where the has been decided the deduction of 6 years, which was set aside, lordship. But subsequently, the aggrieved other petitioners have filed in PTP, lordship, where the division bench, lordship, has clarified the applicability from 4/12/18 was set aside, lordship.
so it will apply for all because of the fact that Sanjita Roy, there is no mention that it will apply prospectively.
Yes, lordship. Yes, lordship. Therefore, the petitioner is entitled to entitle his pension from the date of the retirement, lordship. That is 31/5/11, lordship. Thereafter, petitioner has submitted his representation, lordship, that has not been
You
considered.
say that you are covered by the 2013 notification.
Okay.
What is the reason behind holding that about this 2 years?
I am covered by the honorable division bench judgment, lordship.
Yes, Mr. Naik.
Lordship, authority will verify and pass necessary order, but only one I'm thinking, Lordship, why the prayer for family pension is missing.
Okay, for-
Where statutory is concerned, he will get the benefit.
Yes, madam. You need to bring in the family pension also.
Yes, Lord.
Wouldn't that be later on? You'll be only entitled to the area. But your husband had expired.
Yes,
So don't you think a family pension will be required?
yes, Lordship, yes, Lord.
I think you withdraw it and file a refresh, asking for the family pension.
Prayer, Lordship, I have to, Lordship. Or
That I think you need to incorporate it.
or I'll file it additional affidavit. Thanks.
That will include the amendment again. You just add one line out there in the prayer, no? That the family pension, then I think it will be a composite relief. Because otherwise your relief will be only you will be entitled to the area of your husband. But what about the family pension? Again, do you want to come again file another petition? Better withdraw and file a fresh. Only that you add that you will be entitled to the family pension, although whether it is there
Yes, Lordship.
somewhere in your petition, if it is there also, I can.
Representation, Lordship, there is mention of family pension, but it might bear this. 1023, Lordship, page number. Complete presentation, Lordship. Page number 102. I am also eligible for payment
No,
of
no,
premium.
no, not here. Yeah. There is a petition, there is no release. All are releasing the areas.
Only area, Lordship, paragraph 17.
Better you withdraw with the liberty to file. Huh? But Miss M. Nirola, the learned counsel appearing on behalf of the petitioner, Mr. P. Naik appears on behalf of the
1, 2, 3, 4, and 5. Lordship.
Public Works Road Department
Lordship, I
of
am
the
for six.
government of Assam. And Ms. M.T. Bora appears for the Directorate of Pension. And Ms. and so appears for the Accountant General AE Assam. The learned counsel for the petitioner has submitted that inadvertently the prayer for the family pension to which the petitioner now would be entitled to have been not mentioned in the writ petition. Accordingly, she submits that she may be permitted to withdraw with the liberty to refile by adding the necessary averments as well as the prayer to the effect. Taking into account this submission, let the petition stands disposed on withdrawal. However, the petitioner is granted the liberty to refile it by adding the necessary averments as regards family pension as well as averments and relief for family pension.
Martin.
My pleasure, dear Lordship. Lordship, I am appearing on behalf of Housepet Malad. Malad, I could not file affidavit, Malad. May I please some more time to file affidavit because the employees at the Malad, the petitioners before a Lordship are the employees of Housepet Malad, and they are seeking, they are paying for Malad pension amount, gratuity amount from big debt Malad. So may I pray for 2 weeks time, Malad, for the time, Malad.
Without fail?
Without, actually, I have received the parawise comment, my lord.
No, madam, I'm asking you, time is granted
My lord,
without fail.
without fail, my lord, I'll file
Without
without.
fail, then otherwise this court is not going to
My
grant
lord,
an
without fail,
adjournment.
my lord, even I'll file by the next week, but for abandoned question, I'm paying for 2 weeks time, my lord.
Your name?
You dash, my lord.
Ms. Yuta submits that she has received the Paraguay's comments and she would like to file an affidavit in that regard, for which she seeks an accommodation. List the matter again on 26th of April
My lord,
2020.
my lord, can it be on 28th or 29th? I'll be out of station by 26th, my lord. 28th or 29th, my lord.
Let the matter be listed on 28th of April
Deeply obliged.
2023. It is made clear. It appears from a perusal of the dated 5/12/2022 as well as 14/12/2022 that the respondent number 3, 4, and 6 have on the earlier occasions sought for adjournment to file the affidavit in opposition. This court grants the adjournment to file the affidavit without fail by 21st of April
My
2023.
lord, my
The petitioner, if so advised, would be at liberty to file their reply. Yes.
Hello.
You have to pay the court fee. There are 9 petitioners. You have paid only the court fee of only one person.
My lord, I'll do the requisite.
The learned counsel, it further appears from the records that although there are 9 petitioners, but the court fee of only one writ petition have been paid. The learned counsel for the petitioner submits that he shall do the needful in that regard on or before the next date. Before the next date.
deeply obliged.
14.
May I please?
Hmm.
Some petitioner was the LP school teacher, my lord. He retired in the year 2016, my lord. Till now, my lord, his pension is not keep, my lord.
Here, my lord, I have a old instruction dated 20 October 2022, my lord. By this communication, my lord, director has asked the secretary to, my lord, accord necessary approval from finance department for waiving of the, my lord, excess amount drawn by the petitioner.
How much excess?
Lordship, one increment was passed, lordship, and it's the page 49, my lord. It's page 49, my lord. And next 6, my lord. In partial modification of this office issued under memo number so and so as per provision under.
No, which is the excess amount?
Excess amount is mentioned, lordship. That page, my lord. Page 51, my lord.
Huh? How much is the excess amount? Have you paid?
As per my communication, my lord, excess drawal of pay rupees 4 lakhs, my lord. 4,09,993.
Because of overstay.
My lord.
My lord.
How did the excess drawal happen?
Due to wrong fixation of pay, my lord.
That
Lordship, these wrong fixation not actually. Lordship, and it's page 51, my lord. The finance, finance and account officer, my lord, director of pension Assam, wrote a letter, my lord, to the director of elementary education at page 51 and next 8, my lord. They already waived this amount, my lord.
they will?
Waived, my lord, excess amount.
Where?
Lordship, kindly see closed 1. Pay determined on 1/1/1981 is not admissible. Pay 1/1/91 could be fixed at rupees 537 instead of rupees 573. Subsequent fixation be done accordingly. Entered in the SP due and roll statement if prepared, and excess payment may be assessed, including leave encashment benefits. If the excess amount made was not due to misrepresentation or fraud expected on the part of the pensioner, the department may waive the recovery of rupees up to 1 lakh. With approval of the PPG department, so and so with finance department, government
Number so date of receiving the ad hoc grant and provisionalization one thing. In summation of the new pension steps should be taken to see that above deficiency does not recur again, leading to return the pension proposal. Thereafter, another
Are you
letter,
receiving the pension?
no, I.
Oh.
Due to this fact, my lord.
Mr. Bora, what should the court do now?
Because my lord,
Have you
excess
seen
role
the
is,
last order?
my lord, yes, I have seen, my lord. After that, my lord, step has been taken, my lord.
Then what happened?
My lord,
If no steps are taken as directed, the personal appearance of so and so shall be considered.
my lord, I have gone through the order, my lord. We have taken the step, my lord.
Yes.
Director asks the secretary, my lord. My lord, may I read the letter, my lord? My lord, pension case in respect of Nomorali Borghamalo, Madam, with reference to the subject cited above, I have the honor to enclose herewith the pension paper along with service book in original received from the District Elementary Education Officer Kasar regarding excess roll of pay of rupees 4,09,993. Only in respect of Nomor Ali Borghamalo, retired headmaster of Nomol Ali ABMEM under Kasar district. The petitioner in WPC number 2707 of 2020 arise due to wrong fixation of pay along with service book rectified with the actual admissible of pay. The government is therefore requested to accord necessary approval from the finance department for waive of the excess amount of the petitioner in WPC number 2707/2020. Here, my this communication of 20 October 2020.
This was written to
My secretary to the Government of Assam Department of School Education by the director.
So why should this court wait for this, all these things which are going on between interdepartmental? He's suffering. We set aside this excess. Then the matter ends. He can do well, very well. Rafiq Masjid makes it clear you cannot. And it is the fault is not his. You have
Page 53, Lordship.
Yes.
The communication, the proposal was returned to the District Elementary Education Officer.
Hmm.
The first part here, the counsel for the petitioner has read, but the point two, the date of receiving ad hoc grant and provincialization one thing, that information was also required, Lord. Date of receiving ad hoc grant and provincialization one thing. On to this ground, it was
The
returned.
problem arose because of you. Whoever. It should be 537. You made it 550. And because of that, his salary went. You did not notice. At the time when he retired, this has happened because of the accountant general or the finance director of pension pointing it out. Then how do you do it?
Well,
We set aside this excess.
last month 10 days may be given. I'll bring the instruction regarding
For
the-
what?
regarding the communication, status of the communication 20 October 2022, madam,
Regarding?
which was sent by the director to the secretary
Huh.
for taking necessary approval from the finance department for waive of the excess amount of.
Finance department says that we have no role.
Here,
here to
because
do.
excess amount
This is
more,
between the pension and them.
because excess royal is more than 1 lakh. That is why, my lord,
Understood. It is more than 1 lakh. But how do you take care of it? Because it is your mistake.
that is true, ma'am.
He is not responsible for fixation. The moment this is being done, then I give you 3 months time to finalize the pension and do whatever it. The page 53 letter is very clear. If there is a fraud or misrepresentation on his part, then very well. That is not the case. If you look into Thomas Daniel judgment, you see Jagdev Prasad judgment, all the judgments categorically says that if there is a case of fraud or misrepresentation, then it is a different. It is not your case in the affidavit also. We have not stated to the effect that it is because of the petitioner's fault. You have made it 537 to 573. Then why shouldn't Rafiq Masti apply? Yes, Mr. Solia.
We have not made any
They are
recovery.
putting the gun on your shoulder and firing. Tell me.
We have not made a recovery as of yet. So the
Understood, but he has not received his pension. When did he retire?
2016, my lord.
Oh,
Yes, that has.
that is enough of a recovery.
Regarding the recovery, we are not making
6
any
years already
recovery.
elapsed.
They are now to finalize the pension document, my lord.
Analyze can't be done unless that the amount is regularized.
And this information, also date of receiving ad hoc and flight, that has to be provided by the department.
They have not done it. Then
Well, as a last, 10 days time may be granted, I will up to bring up to the inspector.
I grant you 10 days time without for direction for interest. Putting you to notice to interest. Heard Mr. J.U.N.M. Loskar. The learned counsel appears on behalf of the petitioner. Mr. P.K. Bora appears on behalf of the Elementary Education Department. Mr. S.R. Borua appears for the
Director of
Director of Pension, and Mr. A. Solia appears on behalf of the Finance Department. Mr. Ardhor appears on behalf of the Accountant General AE. The petitioner herein retired on
My lord. 29/2/2016, my lord.
29/2/2016. You got your provisional pension?
No, my
The petitioner, however, have not got his provisional pension or the DCRG.
Okay.
Have you got the DCRG?
No, my
On account of a wrong fixation of the pay of the petitioner, as was noted by the Office of the Director of Pension on 10/7/2019, the petitioner have not yet been paid his provisional pension, the DCRG, as well as his regular pension have not yet been finalized. From the deficiency as pointed out by the Finance and Accounts Officer of the Director of Pension dated 10/7/2019, it appears that the pay was determined in respect to the petitioner on 1/1/1983 should have been rupees 537 instead of 573. Nothing appears on record that the fixation of the pay made on 1/1/1981 and thereafter the subsequent fixation of pay which have been done as regards the subsequent fixation of the pay, the petitioner had any role in the same. From the affidavit also, there is no allegation that it was on account of fraud or misrepresentation which had resulted in a wrong fixation of pay insofar as the petitioner is concerned. It further appears that on account of interdepartmental correspondences which is going on, the petitioner has been deprived of his pension till date. Considering the above, also at this stage, this court may also find it relevant to take note of that Mr. S.R. Borua, the learned counsel appearing on behalf of the Director of Pension, had pointed out that without receiving the ad hoc grant and provincialization, which was mentioned out there on 10/7/2019 from the Elementary Education Department, it is also difficult for the Director of Pension to finalize the pension papers. Mr. P.K. Bora, the learned counsel for Elementary Education Department, seeks for an accommodation of 10 days list the matter on 19th of April 2023, on which date the learned counsel appearing on behalf of all the respondents shall apprise this court as to whether any steps have been taken for the purpose of as to what is the present status of the pension proposal of the petitioner. Full stop. This court further puts the elementary education department as well as the Directorate of Pension to notice as to why interest at the rate of 15% should not be imposed upon the erring official upon the said department for the delay in processing the pension of the petitioner. Full stop. The said amount for the from the departments from the concerned department to be recovered from the salary of the erring official for the delay in processing the pension of the petitioner. Please record.
16.
Yes, Mr. Borua, you are seeking accommodation last time, 10 days. Where are you? Yes. Yes, madam, what is your case?
Lordship, release of regular pension. I mean, C. Borba is appearing in this case. She is of late.
Which department? BTC?
Lordship,
Suppose.
Dima Hasao, Lordship.
Dimahasao?
Lordship.
So they will send the papers.
Yes, CFP proposal, Lordship.
They are not sending it.
Perhaps not, Lordship. That's right.
Dimahasao or BTC? Principal Secretary BTC.
Yes. Baksa district. Yes,
I
it is
can-
Baksa district.
So the BTC,
Yes.
not Dimahasao.
Oh, I can.
It is.
You gave me a wrong paper? Yes.
Lordship, I have an instruction.
Wait. Ah. Given a wrong. So, madam, you got everything?
C. Borba is appearing in this case. He is on legs at court number 12.
You can say that also. I'm only asking you, you have got everything. Here it has got, you wanted the pension, pension has been given, DCRG has been given, GPF has been given. What else? Anything else? Your name? K. Borua? K. Borua. Heard Miss K. Borua, the learned counsel appearing on behalf of the petitioner. Mr. S.R. Borua appears on behalf of the Directorate of Pension. And Mr. Madam, your name?
J Das.
J. Das appears
Accountant
on
General.
behalf of the Accountant General AE. And Mr. B. Chaudhary appears on behalf of the BTC. NJ Khatuni, are you appearing? On behalf of respondent number 1. And Mr. A. Sulia appears on behalf of the Finance Department. The learned counsel appearing on behalf of the Directorate of Pension has submitted that the pension as well as the final pension as well as the DCRG of the petitioner have already been settled by the Directorate of Pension. And in that regard, on 7/11/2022, 2 communications were issued to the Treasury Officer, Rongia Treasury. In the first communication, the Treasury Officer, Rongia Treasury, was forwarded the PPO number ADP/PPO/GPO/2022/0866766 in favor of the petitioner of an amount of rupees 35,070 per month with effect from 1/8/2020. In the second communication, the Treasury Officer, Rongia Treasury, has been informed that the total DCRG payable to the petitioner was rupees 13,53,858, and out of the said, provisional DCRG of rupees 12,18,858 has already been paid. And as such, the remaining amount was directed to be paid. It further appears that the said communications were also forwarded to the petitioner. The said documents are kept on record and marked with the letter X and Y respectively. Miss So-and-so, the learned counsel appearing on behalf of the Principal Accountant General AE Assam, have also mentioned that the Senior Accountant Officer of the Office of the Accountant General AE had also issued a communication to the headmaster Uttar Betna High School thereby directing the said authority, the later, for payment of the amount of rupees 7,53,179 on account of the entitlement of the petitioner in accordance with the General Provident Fund bracket Assam Service Rules 1937. The said documents are kept on record and marked with the letter Z. Taking into account the same, the instant petition therefore stands disposed of as the grievances of the petitioner is met. The, the what about the excess drawal has been regularized?
It has been,
It has been regularized.
Yes, Lordship, it has been regularized, and we have sent letter to the Accountant General saying that it was not due to the fault of the petitioner.
It is also relevant to take note of. Disposed of. It is also relevant to take note of the submission made by Mr. Bibo Chaudhary, the learned counsel, appearing on behalf of the respondent BTC, to the effect that the excess withdraw salary with effect from 1/1/1996, which was sought to be recovered from the petitioner, have been waived, inasmuch as that there was no fault on the part of the petitioner, which for the purpose of fixation of his salary, here or her salary. And as such, necessary communications were issued to the Director of Pension, waiving the said amount. Consequently, in view of the above, as the grievances of the petitioner have been duly met, the instant petition stands disposed of with a direction to the Treasury Officer, Rongia Treasury, to pay the amounts to the petitioner, if not already paid, in terms with the communications dated 7/11/2022. With the above petition.
Lordship, but till as per instruction, he has yet to receive the pensionary benefits, retirement benefits.
That is what I gave the direction. Everything else has been done.
Time period may be fixed.
I've said forthwith.
I didn't get that.
Our certified copy of the petitioner is directed to serve a certified copy of this order to the Treasury Officer. Which one?
Rongia.
Rongia. For due compliance.
18.
Yes. Some interlocutory application has been filed.
Yes, Lordship.
What is it?
Filed an interlocutory because they are making some payments.
Huh?
Some of the institutions, wildlife protection institutions,
They praying for stay of any payment to
Yeah, they are
respond
making
without
some
seeking the
payments.
permission. Who is the respond number 4?
yes.
Who are you?
I'm the mother of my son died on job.
Very well. Who appears for respond number 4?
I thought I am the widow.
How can you stop?
Lordship, once first time when this payment came, that time they called me and they gave 50-50 to both of them. Now suddenly another payment comes, not a single whim to me or nothing to me, and they release this check of 3 lakhs
Who?
to respondent number 4.
But how can I help you?
Lordship, my humble submission is that this portion they are going on doing, I know that they are going on doing silently, Lordship. That
No,
is
there
the
is
main
no
problem.
silently business. This is being done as in
Lordship,
terms with
my
143.
prayer is before this Lordship is for the pension.
You want to change these rules, you have to change the rules. By going to the, becoming a member of the government. Otherwise, I can't help you. It's sad, but that is what is the law about.
It's very sad. Again, they are bringing in allegation in this reply that she has been thrown out of the matrimonial home, which is totally false. Again, I'm only person living there.
You are
And my
the, you are the
daughter-in-law is
mother.
there. Yes. Who will throw her out?
No,
There's
this-
nobody.
Something have
Man,
been
this kind of
shown or
allegation
whatever
should
may
not
be,
come
that is
before
a
the High
subject
Court.
matter of a criminal proceeding, or
Yes,
whatever may
Lordship.
be.
Those,
But how can I help you with this, what you are asking? This court can't change the law. Law is already set. What is your prayer? Let us see. Maybe admit the issue a rule calling a wire mail or years there shall not be issued and PP. What is your prayer, madam?
Lordship, in the IA,
No, in your main thing. Direct the concerned authorities to pay at least 50% of the pension and allowances to the petitioner, or direct the authorities to submit the equivalent. Madam, how do I direct?
Lordship, the provision is there. That since I am the head of the,
It will be within the realm of a civil court or whatever may be, or you may file it that you are if she's working somewhere.
which is working, Lordship.
So if she's
Same
working
department.
to get something out there, but unless that law is not challenged, how can I do anything? As per law, you are not entitled to.
Lordship, 142 says, as per amendment, it says that I can.
As per amendment, what does it say? It's the 2008
Family pension,
amendment.
Lordship.
Where?
Notification dated 20th August 2015, Lordship.
Yes, what does it say? Yes, tell me where.
143, Lordship, Rule 143, 1 and 2, that is the amendment. The following provisions are included in Rule 143, 1 and 2 of the Assam Services Pension Rules 1969, in line with Assam India's Services Death Cum Retirement Benefits Rule 1958. For the purpose of this rule, family shall include the following relatives of the government employee apart from the relatives indicated from A to D in the existing provisions of Rule 143, 1 of the Assam Services Pension Rules 1969. E father, F mother, G eldest surviving brother up to the age of 18, H eldest surviving sister up to the age of 21 or marriage, whichever is earlier. Number 3, the family pension under this rule shall be admissible to the following provisions of Rule 143, 2 of the Assam Services Pension Rules 1969, apart from which A to C in the existing provisions to the father, failing D to the mother, failing D and E to the eldest surviving brother up to 18 years of age, failing D, E, F, E and F to the eldest surviving unmarried sister. as per this provision, Lordship.
Then,
So I'm the mother.
so
For
do
the
you mean
family
that
pension.
the family pension, can it be
Of my son.
segregated?
Lordship, my son, he died, Lordship.
Understood, but can it be segregated? Can the authorities give two family pension? No. Because one still, you see, 143(2)(a) still remains. The pension will be admissible in the case of a widower up to the death of her in the family, in her death or remarriage, whichever is earlier. In the case of minor son, who until 12, so in the case of unmarried daughter, until she attains the age of 21 years or married, whichever is earlier. Then comes to the father, then failing D to the mother, failing D and E to the eldest surviving brother up to 18 years, failing D, E, F to the eldest son, so and so it will be only in the case of the two or more, a pension will be payable to the eldest of the surviving. On her death, it will be payable to the next surviving, if any. The term eldest would mean the seniority pension awarded under there will not be payable to more than one member of the family at a time. It will be first admissible to the widower, and thereafter to the minor children. How do you take care of 143(3)?
There is no children in this case.
No, but children. But it will only be given first to the widower, and failing each, it will go to the others. So how do you take care of this? Unless you get yourself elected in the legislative assembly. You withdraw. I give you the liberty to approach the authority, and the appropriate authority will consider in the future. That is the only thing best I can. I can't help you afterwards. Because if I have to dispose of, I have to dismiss. And once it is dismissed, it's foreclosed for everything. Unless you win the election.
We give a proper application again, then
And the authorities may consider
let them go.
taking into account that full bench judgment. Although it was a case of Muslim,
That was Muslim.
but
yes.
then also one line out there, down below, may help you out.
Before the appropriate. There it is said, before the damages are to be in way of damages before the appropriate authority by filing appropriate for application.
Understood. Then see the last line of the judgment. It shall not be a bar to the authority in the appropriate
No, it is
proceeding.
open for her.
No, for the authority to, in the taking into account the particular situation, to separate it between them, and the judgment of this court shall not act upon. Isn't that the last line?
Yes.
The last line we help madam with that. After all, you see, yes, the law is this, but something needs to be done. What will happen to the mother? She has no source of income. Tell me, where will she survive?
That is true, my lord. But behind the scenes, also a lot of things are going on. She is currently looked after by her 3 daughters who live nearby, and I was thrown out. I'm not going into all these things in a pension matter, but since the allegations were so, I had to file write all those
Okay,
things.
but the thing is, whatever may be, because when she comes in, she has to satisfy one thing, that she was solely dependent upon that person. Only staying out there is a different thing. So can't say that. It is a question of proof that she was totally dependent. If your case is that, you may find it out before those authorities. You can name.
No, Lordship, the case is now as such that my son has expired. So somebody has to manage me. So my daughters they are helpless. They are bound to maintain me now. They're bound to look after me. Otherwise, I'll be on roads. I have nobody to take care.
Madam, I am not
That
going
that
to.
is what my
Madam,
friend,
that,
learned friend is
that is
saying.
a
So
fact which, those are aspects which this court would not like.
his
to do.
logic, that official part is different.
But that is for those authorities to decide whatever they, if they, in the facts of that case, find it, they can very well do it. I am not issuing any writ for that. Miss
Embora.
Embora, the learned counsel for the petitioner. Mr. Yes, your name?
P. Bharadwaj.
P. Bharadwaj appears for the respondent number 4. Yes, Mr. Gogoi.
I for the Forest Department, 120.
Forest. Forest seems to be good for you. PHE, you don't appear.
Morning, I was there. I have
You
summoned
were not
another
there.
court
I was, in spite of this mic, I was shouting out there where the PHE is not there.
I was summoned to court 7, my lord.
And then
The moment I came, it was already over.
PHE's office is there in Norkahulpa.
No, my lord, it's now near the new DC office, my lord. Hengrabari.
Okay. But then also the DC out here gets the instructions very fast. Why the PHE is not giving instruction? It's nearby. Then I thought it was in the hill. That is why the reason must have been the PHE, the instructions, they don't come. And in fact, there is no internet connectivity also properly in that area.
No, that's
I think
well
that might have been the reason.
well in a well-connected area.
Then Mr. D. Gogo appears on behalf of the respondent number 1, 2, and 3. No, 1 and 2. You are appearing for 3.
I can take the commandant, my lord. It's
Commandant
second
is
Assam
him,
Forest
na?
Protection Force.
Oh, this is the same.
Yeah, some forest protection.
1, 2, and 3. The learned counsel for the petitioner admits that in view of the proposition of law as set out in Rule 143 of the Assam Service Pension Rules 1989, she would not like to press the instant writ petition. However, the learned counsel has drawn the attention of this court to the judgment of the full bench judgment of this court in the case of MUSTT Junufa Bibi versus MUSTT Fatma Devi, reported in 2022 SCC Online GAU 2000, and submits that the petitioner that the government, the department, in special circumstances can take a call in giving separate pensions to the petitioner as well as the respondent number 4. And as such, the learned counsel for the petitioner submits that the withdrawal of the instant writ petition shall not prejudice her rights to approach the concerned respondent authority. Taking into account the same, the instant petition stands dismissed on withdrawal. However, the withdrawal or dismissal of the writ petition shall not preclude the petitioner to approach the respondent authorities for taking for approach the respondent authority who may be at liberty to take such steps, pass such orders as deemed fit. I think it. 19.
Maybe.
Yes.
The petitioner before your lordship prepared on 30/9/2017
as an Amin from the Deputy Commissioner establishment. He was an Amin, my lord. But his final pension has not been released as yet.
Huh?
Final pension has not been released. As a result, he's suffering, my lord. Now, my learned friend, my lord,
The pension has been done already, PPO.
My lord, we have issued, my lord, pension payment order, my lord.
Then
Here, my lord, what happened, my lord? Initially, the petitioner,
I got some instruction from you on 7
My lord, my lord.
2023.
my lord, what happened, my lord? Initially, while the pension papers were forwarded, we have seen that, my lord, additional 3% increment was granted to the petitioner. So we raised an objection that in terms of the office memorandum, government notification dated 13/2/2018, the post of Amin that has not been included in the category of, my lord, granting of 3% of additional increment. So we returned the proposal. Thereafter, my lord, the government took a decision, and by notification dated, my lord, 12th of November 2022, they have said that the
Post of
Mondal and Amin, they were also granted the additional 3% increment. Accordingly, proposal has been submitted. We have settled the pension case of the petitioner.
Matter over.
Yes, my lord.
It was over on 7/3/2022.
My lord.
Then why this matter was still there?
Regarding, my lord, 3% of increment that
now,
Yes,
my lord,
because you are entitled
already-
to DCRG of 6 lakh
my lord.
3,855. You have already received 5,98,000.
Yes. So the rest
And your
amount,
pension
he
is
will get, my lord.
19,170.
Yes,
with this observation, my
These have
lord,
already been marked as X and Y.
my lord.
Huh?
And pension has been
mark
granted to
kora
the
nahi
tune
kyo?
of rupees, my lord, 19,170 per month.
এখানে কি বলে X and Y কোন সূত্রে কোথায়? আরে নাই,
Stock include.
পেলে কি কোথায়? X Y mark. ঠিক আছে।
My lord. Yes, yes,
Last moment the matter was taken up.
yes,
na?
yes. That's why,
And
my
at that point of time, you gave these
lord. My
documents.
lord.
exactly, my lord.
Heard, Mr.
A.R. Talukdar.
A. Taluka, Lowland Council for the petitioner. Mr. A. Hassan appears on behalf of the respondent number
5.
5. And Mr. P. Naik, you appear for?
Lord. Yes.
Phone number 2. Mr. M.D. Bora appears for?
6, my lord.
Wait. Mr. S. Doctor appears for respondent number 1
and 4.
and 4.
All.
Ms. P. Naik appears for respondent number 2.
Yes.
Ms. M.D. Bora appears for respondent number 3. Respondent number 3 and 6.
Please, my lord, Please, if GAD.
GAD, you are appearing. A. Fukan appears for respondent number 3. And Ms. M.D. Bora appears for respondent number 6.
My lord.
And Mr. A. Hassan appears for respondent number 5. The case of the petitioner herein is that the petitioner is aggrieved by the action of the respondent for not releasing his pension along with the additional 3% increment as per the Finance Department Government of Assam notification office order dated 13/2/2018. The learned counsel appearing on behalf of the Accountant General, Mr. A. Hassan, had submitted that by the notification dated 12/12/2022, the governor of Assam had, in continuation to the office order dated 13/2/2018, and in pursuance to the cabinet decision in the cabinet meeting held on 8/8/2022, had included the post of Mandal and Amin working in the establishment of Deputy Commissioner and Subdivisional Officer C, along with the Patwaris, for granting 3% additional increment. He further submitted that in pursuance to that, the senior accounts officer have issued two communications dated 16/2/2023. 16/2,
My lord, 16/2.
both.
Both.
Other is 31/3.
No, it was signed on 10/2, my lord. So total letter on that
Huh?
16/2, my lord.
On the 16/2/2023, wherein it has been mentioned that the final PPO of the petitioner have already been made, and the petitioner would be entitled to 19,170 per month as pension. Further to that, by the another communication, the Treasury Officer Karimganj was informed that the petitioner's total entitlement on account of DCRG would be rupees
3,800.
3,855, and out of which the petitioner has already received the provisional DCRG of rupees 5,98,855. Considering the above, the said communications are kept on record and marked with the letter X and Y. Further to that, the order of the governor dated 12/11/2022 is also kept on record and marked with the letter Z. Taking into account the above, the instant petition therefore stands disposed of with the direction to the Treasury Officer Karimganj to make payment of to comply with to do the needful in terms with the communication dated 16/2/2023 issued by the senior account officer of the Office of the Principal Accountant General AE Assam, for which the petitioner is directed to serve a certified copy of this order to the Treasury Officer Karimganj for doing the needful.
Obliged.
Obliged,
Highly
my lord.
obliged.
20.
Only because of Manasab wrong, my lord, incorporation of mine.
Oh, that matter.
Yes, madam.
You have been mentioning only at 4:15 or 5 o'clock when the court is about to rise.
Yes, my lord.
This is the matter.
Yes, madam. Only this portion is Nasiaton.
Which
It is
portion?
corrected also. But she is
Yes,
not able
where?
to get. Page, my lord, 21, annex 6. That's earlier letter.
With reference to this, I have the honor to forward here with an application in original of, along with its enclosure. And so who have paid for family pay. Yes, what is your problem?
Problem is that first time already expired in the year 2013. So
Okay.
she is entitled and it is also corrected. But till that, I am not able to get. That is my grievance. Nasiaton and Nasia. And last communication.
When did the first wife expire?
2013. It is there in it.
Oh, Fatima Bibi.
Yes, madam.
But she also expired on 8/5.
Yes.
Now the second wife of so has paid for family pension, and in this connection she has enclosed with her application the death certificate of so as well as the affidavit, wherein she has stated that her actual and correct name is Nasiatan Bibi instead of Nasia Bewa. Oh.
And recent position is there, man. I have given it.
Now, where is your name mentioned that you are Nasia Bega or something?
The page 24 is there, Nasiaton PP.
Huh?
Page 24,
No,
total
that
list.
is okay.
Next the P.
No, where it has been mentioned that Nasia Beva,
Oh, Nasia Bea.
where is it mentioned?
And that is Malad.
Yes, what is your instructions? Lordship, we have written a letter to the Undersecretary Government of Assam, Lordship, in the month of September 2022, Lordship.
This one?
No, Lordship, this is my instruction.
This document?
Yes, Lord. So, Lordship, this is instruction of September 2022, Lordship. Whether they have forwarded, Lordship, they have to produce the document evidence that they have forwarded the pension proposal, Lordship.
Lordship, may direct Lordship the authorities, Lordship, to meet up the whatever query the AG have, Lordship. Lordship, will dispose the matter, Lordship, directing the
No, no, no.
They have
If we dispose of this matter at this stage, then he has, Mr. H. Das gets another opportunity of filing another writ petition.
In that case, Lordship, I may give you given 1 week time, Lordship. I
Yeah.
will take the latest instruction, Lord.
But second time also they put one letter. At least one letter, my lord. Kindly peruse your lordship. They have already corrected and submitted all papers.
Who?
Uh,
Executive engineer has
yeah.
also sent it to Undersecretary. Whether he has submitted or not. Hello, we'll pass the order at 2, but not disposal. This has to be kept pending. We'll have a look on the next date,
Yes,
but you
yes.
have to send the papers because without sending the papers, if we stop it here,
That direction may be given.
oh, that direction I'll give it. I'll only inquire as to whether you have done it or not. If not done, then we put you to interest.
Lordship. Lordship, note 2 was left out, Lordship. That is clear about it. Because, Lordship, the full bench decision is purely on Muslim law, Muslim women, Lordship, Mohammed, and I went through it.
Note 2.
Note 2, Lordship. A, Lordship, the family pension shall be paid to the eldest eligible member of the family who shall divide it equally among other eligible members.
Where?
And page number 159, if it is the new book, Lordship, 160. Ekon.
Madam,
It's minors and oblique
no.
unmarried.
Present at the time of the death of the widow or widower.
Yes, Lord.
So there has to be other people who is the time of the death of the widower. Here the widow is alive.
Widow is alive. She is the one who will be the recipient.
Understood.
And she will be giving the indemnity at least to one family tree is written there, Lordship. Father, mother, minor child, unmarried daughter.
Understood. But the problem arises is only after the widow dies, not before that.
Lordship, give me one chance, Lordship.
No, nothing doing.
One, because Lordship, if it is withdrawal, Lordship, again, this full bench judgment will not be sufficing, Lordship.
That is the only thing. You want, I can dismiss it, your petition.
Yes, Lordship.
I'll dismiss it.
Yes, Lord.
Okay. I'll file to you.
18.
We'll pass the order
Lodge.
after some. You be here. Yes,
Well, here, my lord, only that I have come to know from my client, my lord, that Department also send it, but only the AG office, my lord, holding this permit regarding that release of the family pension. But from the last 10 years, my lord, I am waiting for the family pension. Only because of that.
Lordship, I have not received any instruction that the pension paper has been received to office, Lordship. Department is the authority, Lordship. They have to produce the
Lordship, fix the
document.
matter tomorrow, day after tomorrow, Lordship.
but tomorrow, day after tomorrow. This
Lordship.
court is today sitting at 12:15 because of the so many other things to be done.
Lordship, only thing is, Lordship, the
Third, Mr. H. Das, the learned counsel appearing on behalf of the petitioner. Mr. N. Upadhyay appears for the irrigation department, and Mr. R.K. Talukder appears for the accountant general AE. The learned counsel for the accountant general AE submits that the papers pertaining to the family pension of the petitioner have not been received by the said department.
Lordship,
they have received, Lordship. They have returned back the same to resubmit it, Lordship.
Have not received, have not received the papers pertaining to the petition, pertaining family pension of the petitioner after having been returned once. List the matter again on 10th of April, on which date the learned counsel for the irrigation department shall apprise as to why the papers have not been sent to the office of the accountant general.
Lordship,
Lordship, that my instruction was month of November, Lordship. If they have forwarded, Lordship, we'll settle it.
We'll see.
Lordship.
18. Huh? Oh, where is she? Yes, madam, where are you? Yes, yeah, ma'am. Heard, miss. Your name?
Embora.
Embora, the learned counsel appearing on behalf of the petitioner. Mr. D. Gogoi appears on behalf of the respondent number 1, 2, and 3. And Mr. P. Bharadwaj appears on behalf of the respondent number 4. The case of the petitioner herein is that she is the wife,
Mother.
she is the mother of one Rubjit Bora since deceased. The said Rubjit Bora, admittedly, at the time of his death, left behind his mother, that is the petitioner, his wife, that is the respondent number 4. The grievance of the petitioner herein is that the respondent authority are paying the family pension to the respondent number 4. And as such, the petitioner, the petitioner has filed a writ petition for a direction that the concerned authorities to pay at least 50% of the pension and the allowance to the petitioner, or direct the authorities to divide the pension in equal half between the petitioner and the respondent number 4. You give me your book. The Assam Service Bracket Pension Rules 1969, for short, the rules of 1969, mandates in the manner in which the pension, the family pension is to be paid. In terms with Rule 143, Your book doesn't have 143. One 143. The family, the term family have been defined. Rule 143.1 stipulates who would come within the ambit of family for the purpose of the rules. It would be seen from the perusal of the amendment to carried out by the Assam Services Pension Amendment Rules 2015. That the wife, wife, in case of the male officer, B, husband in the case of the female officer, C, minor sons, D, unmarried minor daughters, and E, father, F, mother, G, eldest surviving brother up to the age of 18 years, H, eldest surviving sister up to the age of 21 years or marriage, whichever is earlier, would come within the ambit of the term family. Within the ambit of the definition family. Rule 143.2 stipulates as to when the pension would be admissible. Roman 2. In terms of it, clause A of rule 143.2 it is the widower upon the death of her or his death or remarriage, whichever is earlier. In terms with clause B, in case of a minor son until he attains the age of 18 years, in terms with clause C, in case of an unmarried daughter until she attains the age of 21 years, or marriage, whichever is earlier, it will further be seen that in terms with the Assam Service Pension Amendment Rules 2015, pension will be payable to the father as per clause D. In terms with clause E, in absence of the father, the mother. In terms with clause F, the eldest surviving brother up to 18 years if there is no father and mother. And in terms with clause G, the eldest surviving unmarried sister up to the age of 21 years or marriage, whichever is earlier, in the case there is no mother, no father, as well as eldest surviving brother up to 18 years of age. In terms with note 1, it has been mentioned that in case where there are 2 or more widows, pension will be payable to the eldest surviving widow. However, on the death of the eldest surviving widow, it would be payable to the next surviving widow, if any. Rule 143.3. It further appears that there is no, there were it further appears that there has been further amendment to the Assam Service Pension Rules 1969 by the notification number PPG bracket G dot 10/2013/49 dated 9th of August 2018. By the said amendment, Rule 143.2 was further amended. In terms with the said amendment, now 143.2, 143.1 and Rule 143.2 were further amended. In terms with the said amendment, all unmarried dependent daughters were brought within the fold of in terms with the state amendment. Clause 140, Rule 143 1D was amended and was substituted by the term unmarried dependent daughters. Further to that, Rule 143(2) were amended whereby it was mentioned that the pension would be admissible A, in the case of widower up to the date of his death or remarriage, whichever is earlier. Semicolon. In the case of minor son, until he attains the age of 18 years. And in terms with clause C, in the case of an unmarried daughter, until she attains the age of 21 years or marriage, whichever is earlier. With a proviso that the family pension shall be allowed to continue beyond 21 years of age to an unmarried dependent daughter of a government servant, oblique pensioner, subject to the fulfillment of the conditions mentioned therein. Further to that, Rule 143 Roman 2 to Rule 143 Roman 2, there has been addition to it, there were insertion of three notes, that is note 2, 3, and note 2, note 3, note 4, and note 5. In terms with note 2, it is the submission of the learned counsel for the petitioner that the mother, being the eldest member of the family, she is entitled to get the family pension. As she is the eldest eligible member of the family who has the responsibility to divide it equally amongst other eligible members. Taking into account that it is the case of the petitioner, the entire case of the petitioner hinges upon note 2. The same is reproduced here in below. In note 2 to 59. A perusal of the above quoted rule, note 2, would clearly show that the same would be only applicable upon the death of the widow oblique the widower. Taking into account the respondent number 4 is the widow and she is still alive, the question of application of note 2 to the facts of the instant case does not arise. Consequently, this court does not find any merit in the petition for which the same stands dismissed. I to dismiss on the ground that in view of the dismissal of the writ petition.
Board action list, item number 1, unlisted.
Yes,
My lord, in this case, I am appearing for respondent number 6, my lord.
who is he?
The principal of the Masgat. Now, my lord, the issue.
Oh, yes.
Yes.
You have not sent the papers.
No, we have not been communicated till now, any paper from their side.
Regarding what?
That she has been transferred or she requires the NOC from the school. Nothing has been communicated to us. So we are not in a position at that time to get the information. Then subsequently, since she was absent, we have communicated to the higher authority also that from 22 December, she was absent. So to take proper instruction to what to do.
For what?
My lord, we have not been getting any information about her transfer. So we are waiting because from 22 onwards, December 22 onwards.
No, the thing is the petitioner have joined.
Yes, yes.
Pursuant to a transfer.
That has not been submitted before us, my lord. That is the
What?
straightway.
Lordship may kindly see Annexure 7. It is communicated, Lordship.
Annexure 7, it is
Annexure
given
7,
out
page
there
26,
on
serial number
recommendation
6.
of the council of so-and-so Rumi Kolita. You are Rumi Kolita?
Yes, serial number 6, Principal Masbat Higher Secondary
So-and-so
School.
of PA is hereby
It's
transferred
communicated.
at her own pay and grade pay and posted at Tongla High School against the resultant vacancy of Nalini Boro.
Now, Lordship may
Now,
kindly see the copy
after that,
forward.
it has been joined and it is under the signature of the principal of Tongla Higher Secondary School. You are Tongla?
No, no, my
This
lord.
is respond number 6.
Now, anyway, my lord, since she has moved before this honorable court, we have.
Now, you are not getting because he is not issuing that last paid rod.
Yes, Lord.
Why you not doing that?
Yes, yes, my lord. We are not aware of that. Since she has.
Now
already-
you are aware?
Yes, yes, we will definitely.
When?
Not tomorrow? No.
Very well. We dispose it of.
Only,
No, Lordship,
only
may
one
let
issue.
them, let them issue the order, Lordship.
My lord,
That
only
is his
one,
order.
only one
You
issue.
don't want to file a contempt.
Otherwise, Lordship, since Lordship December, I am hanging. Lordship.
Your prayer is this. Directing AR to release the order from Masbat HS School and last pay certificate.
Yes.
And should not be issued to the respondent authority to release the monthly salary of the petitioner with effect from so-and-so as subject teacher of Tongla. Now, who is appearing for Tongla?
Tongla is respond number 5 is a formal party because already.
No, but you are seeking a direction for subject serving at Tongla, for passing an order for release of the monthly salary. Are you not asking?
No, I am asking, Lordship.
Then
but
how
only
can this
the
court
only-
issue a writ?
Only hurdle is Lordship. I have impeded respondent, Lordship.
Understood.
Yes,
So without they be appearing out there, have you served them a
Yes,
copy?
yes, Lordship. I think the affected has filed Lordship affidavit. Trustee service I have taken.
Yeah.
In my affidavit, I have stated, Lordship. We received it. Last affidavit, Lordship, I have annexed. The affidavit filed on Lordship on 19th of March, Lord. Received it. Respond
You
number
have
6.
served upon whom?
Upon the respond number 6 as well as the respond number 5.
Sir,
Trustee service as well as the register steps also. I have enclosed, Lordship, the received copies there, Lordship, kindly see the affidavit, page number 37. Affidavit filed on the trustee service.
this is whose signature?
Respond number 5. This is the principal of the Tongla Higher.
Why no seal, no nothing?
Tongla Higher Secondary School.
Yes. For respond number 6, notice issued for respond number 6, notice upon respondent number 5, the service received, notice issued upon respondent 5, which is the fifth. Phone number 6. Notice by issued upon respondent Chalo. We do one thing. We direct you to issue that.
My lord.
Heard Mr. A. Decker, the learned counsel appearing on behalf of the petitioner.
My lord, only one issue, my lord.
Yes.
Right now, of course, that lordship will pass that order. There is no teacher of this Assamese medium now after going of this petitioner, my lord. And there for no ML teacher that Assamese medium
Where?
in this Masbat school. So if that lordship will kindly make an observation that the authority will take, because since there is no teacher available, students will be suffer. No ML teacher is.
He was a MI teacher.
Yes, yes.
But what can I do?
Yes, my lord.
Because it is between you and the authority.
My lord, I have already communicated.
So the authority, if it has happened, but how can you not release his? He
No,
has not been getting his salary because of you.
Absolutely correct, my lord. That is not only one.
No. How can I issue that observation? The observation, if I put out there, that will be another subject matter of another litigation.
My lord.
I can't help you with that. Yes, Department of School Education. Mr. N.J. Khatuni appears on behalf of the respondent number 1. And who appears for BTC?
R. Musari. I have informed him also.
Mr. B. Chaudhary appears for respondent number 2.
R. Musari.
R. Musari.
Yes, Lord.
Mr. B. Chaudhary is there, na? You can put him. I saw him today. I don't know whether Mr. R. Musari is there in the court.
R. Musari is also present. Yes,
Is he there in the court
yes,
today?
yes.
Mr. R. Musari appears on behalf of the respondent number 2, 3, 4. Full stop. None appears for respondent number 5. And Mr.
S. Sharma, my lord.
S. Sharma appears for the respondent number 6. The grievance of the petitioner herein, as noted in the order dated 1/3/2023, as noted in the order dated 1/3/2023, is that on account of non-furnishing of the release order as well as the last drawn pay certificate by the principal of Masbat High School, High Secondary School, the petitioner has not been able to get salary. The learned counsel, Mr. S. Sharma, submits that they had no information as regards the requirement of the same. He, however, submits that the said respondent number 6, the principal of the respondent number 6, shall take necessary steps forthwith for issuance of the release order as well as the last drawn pay certificate of the petitioner. Taking into account the same, this court fixes the matter again on 19th of April, 21st of April 2023. In the meantime, the respondent number 6 is directed to issue the release order as well as the last drawn pay certificate of the petitioner. Stop. The registry shall also indicate as regards. Further to that, it also appears from an affidavit of service being filed on 23/3/2023. That the respondent number 5 have received the service the respondent number 5 have been served through the dusty. Considering the above, the service upon the respondent number 5 is deemed to be complete. Pusto. Let the matter be listed as directed above for further consideration.
Obliged. Obliged.
Item number 12.
Yes, you file a affidavit.
Yes, yes, my lord.
What is it?
My lord, his prayer for area salary was rejected by the order dated 1st of April 2023.
Yes, why?
Because my lord, his initial appointment was illegal, my lord,
Oh,
which has been found, my lord. I have elaborately stated in the.
you got your affidavit?
Yes, sir.
Go through it. If you want to file a reply, file it.
Yes, sir.
The learned counsel appearing on behalf of the
Elementary education.
element, Mr. Ente Katunia, the learned counsel appearing on behalf of the Elementary Education Department submits that they have filed an additional affidavit in the instant petition. The learned counsel for the petitioner submits that taking into account the state stand taken in the affidavit, you would like to take instructions. Let the matter be again listed when
On 8th of May.
on 12th of May. The petitioner in the meantime, if so advised, is given the liberty to file their reply by 8th of May.
17.
It is your lordship. In this matter, your lordship has directed the petitioner to submit the application, lordship. On last occasion, government says that no application was filed. I also prayed for filing an application.
Submitted
but
before this court as per his instructions, the respondent number 6 has informed him that the petitioner yes, respond number 5 and 6, who is appearing?
5, 6, 7. Elementary education.
With whom is the service book?
It is the Dismissal council matter.
Oh, Dismissal is not here.
Yes, madam.
Dismissal, very difficult. PhD department. Okay, none appears for the petitioner on call, as well as none has appeared on behalf of the Dimahasa District Council. Taking into account the same, let the matter be listed immediately after view.
21.
Ms. R. Chaudhary appears on behalf of the respond number 7.
Yes, lordship. Lordship, may I say one thing? In the meantime, may I apply for before the concerned authority, lordship? They have already applied as per information. lordship.
You are second one?
No, I am the first one. Please,
Apply. Who has asked you not to?
as your lordship on last occasion directed the petitioner to apply. Lordship, of that also I have pointed out that whether I should.
Madam, you applied it. Nobody is asking you not.
Lord.
But this is not your petition. Petition is his. You apply it if you think it. I only, if I remember, on that last occasion, if I remember, they were in the next of the kin certificate.
Lord.
The your name was there and his name was there.
Yes, her name was also
Now
there.
he wants to submit to that effect.
Lord.
And therefore I said that as that next of the kin certificate is clearly given out there, he submits or you submit, yeah, but as he was the petitioner, I asked him to submit.
Lord.
And it seems now he knows that it is not there. So he's asked, he's not
No,
submit.
lordship, Mr. K. Mojumdar went for Umrah house, lordship. He informed me that his junior will remain present, lordship.
Okay, but he's not there.
Lordship.
But anyway, you are at liberty to submit.
Lord.
Nobody has asked.
Obliged.
Yes. Mr. B. Talukdar. Oh,
In this case, my lord,
yes, area salary.
regarding area salary, my lord, director has
ask the district elementary education officer to submit the proposal of area salary.
Half of the amount he has received.
Mal-
Oh, that one, provincialization.
Area salary. Well, he's
When I was taking bench two, is that the case? No, no.
no.
Okay.
Here, my lord, he is receiving regular salary, but regarding area salary from 5 to 2021 to 28 to 2022. My lord, here, my lord, proposal.
No. Here was a case where from 5 to 2028 to 28 to 3 2022,
My lord,
he has not received.
received, my lord.
But after 1-3, because initially when he filed the case, it was for a longer period.
Yes, my lord.
In the meantime, he got something.
My lord,
The earlier amount you have not paid.
my lord.
Why?
The proposal has been submitted by the district elementary. My lord, here, director has asked the district elementary education officer Nagaon to submit the area proposal regarding this period, my lord, from 5 to 2021 to 28 to 20.
Yes, I told you it was my order.
My lord, on the basis
Page
of lordship
27.
order, my lord, he is
Ah,
receiving
I
regular.
told you, you are saying no. When I was taking bench two, remember? There are two matters like this. One is this and one is one Razia Khatun. Huh? I remember those names.
Item 24.
Yes. Is there?
But item number 24. Lord.
Oh, it would be same lawyer?
No.
You are there? Very well. You got your salary?
No, half has been given, but
Oh, that period have been given. 1 year they have
1
given.
year
The
given
earlier
and
earlier period has not been. 19.9?
In 5 to 21 to 28 to 2022. This period has not been given. Last order reflected.
You have not got from 5 to 2021, na?
My lord.
To 28 to. Yes, Mr. Bora. Both the matters.
My lord, in item number, my lord, this 21, my lord.
Hmm.
My lord, director has asked the district elementary education officer Nagaon to submit the area proposal.
This one?
My lord.
5492.
5492. My lord.
And the other one? Both were taken last time, Mr. He has got it?
My lord, here also, my lord.
Same,
my lord. On first
Recently, my lord, very recently.
First on for
But
April, my lord.
why all these things are going on? Everybody knows that he has been appointed properly. What is all this respect?
Because of
When you have paid the second portion, why not the first portion?
my lord, regarding my lord, first portion, my lord, due to passing some stay order by this honorable court.
The stay order was
In,
vacated
in other cases, my lord, connected.
and the petition was dismissed. If I'm not wrong.
The liberty was given to
For filing appeal, and he has not. You don't know whether the appeal has been filed. I remember. Oh, then-
Here also process is on, my lord.
who is going to pay the interest? Director of Elementary Education.
Due to passing order by this honorable court, my lord, there is salary has been stopped, my lord.
Understood, but this court has been issuing notice after notice, but nothing is happening.
Now process is on, my lord.
Huh?
Process is on,
Now,
my lord.
how? What is this process business? How is a person going to survive without salary?
In some in some cases, my lord, after passing order of this honorable court, petitioner not serve the copy to the authority. That is why authority no knowledge.
Understood, but then also this court had issued notice as far back as on
True, my lord. But this
8/2.
as soon as possible,
Then when?
up to 2 weeks.
Yes, okay. We'll fix it in the month of May. But any further delay will encompass interest from the date of payment.
Then some more time may be
That
granted.
observation may be given. Lord.
That obvious.
Some time
Yes,
is-
say Nam Kirali. I heard Mr. P.K. Bora. Vitate. Beleg order.
some more
The
time may
learned
be
counsel
granted, my lord.
appearing on behalf of the Elementary Education Department. This court provide order dated at that whole 5492 13/3/2023 and 6248 10/3/2023. Had directed the Elementary Education Department to apprise this court as to when the payment would be made. The learned counsel appearing on behalf of the Elementary Education Department submits that there are certain interdepartmental correspondence going on between the as regards the area salary. This court fixes the matter again on 17th of May 2023. Full stop. The entitlement of the petitioner herein is not disputed. The only reason why the payment has not been made is on account of certain interdepartmental inquiries being made by the concerned officials. Taking into account the same, this court grants the respondents to take the necessary steps on or before the next date and apprise this court as to when the amount would be paid to the petitioner. It is made clear that if the amount is not paid, this court puts the Director of Elementary Education, the Department of Elementary Education to notice as to why interest at the rate of 15% should not be paid to the amount to the petitioner from the date the amount was due to the petitioners, and as to why the said amount should not be recovered from the salary of the erring officials. List the court.
Lordship, I'm sorry for interrupting, Lordship. Item number 11, Lordship. Lordship has directed me to withdraw. Lordship, my prayer is limited there only because the petitioner has received the family pension, Lord.
You are receiving the family
Yes,
pension.
Lordship, it made particularly, Lordship could not annex the PPO, Lord. Lordship, may rather pick the matter. Day after tomorrow, I will file an additional affidavit bringing on this record.
You have got the family pension.
Yes,
Are you getting the area?
Yes, Lord.
You have got everything.
After 2018, Lordship, we have received, Lordship, but prior 2018, from the date of retirement, we have not received the arrear pension.
Why haven't you not mentioned in your petition?
I have mentioned that prior 2018, we have not received. After 2018, we have received.
Have you mentioned that?
Yes. Paragraph 13, Lordship,
What does it say?
the petitioner has received the pensionary benefits from the date of the judgment dated 4/12/18, but the petitioner has not granted the arrear pension from the date of the retirement.
Okay. We'll have it on 10th to item number 11.
11.
Huh? To have it on 10th. 10th, huh?
Obliged.
You inform Mr. P. Nayak
Lordship,
about it.
I have informed.
I know 23.
This matter, my lord, I
I
need
for 22, my lord.
some more time, my lord.
22. 22 key.
Not updated, my lord.
Oh, wait. This is given only to upgraded matter. Yes,
In the
Mr.
last
Taluga.
occasion, your lordship directed me to apprise this code.
Oh, when the area
My
salary of the
lord.
petitioner for the aforementioned period shall be sanctioned and disbursed. When?
So I pray some more time, my lord.
Oh. How much?
On 12/5. On first week of May, my
First week?
or along with this matter, my lord, 12th.
Okay. Mr. B. Talukdar, the learned counsel appearing on behalf of the Elementary Education Department seeks for a further accommodation of 3 weeks to obtain the instruction in terms with the order dated 13/3/2023. List the matter again on 12th of May 2023. It is made clear that if there is no concrete information, and it is made clear that if the respondents do not provide the information as sought for, this court shall be constrained to pass appropriate orders for imposing interest on the next returnable date.
Deeply obliged.
I mean, NJ Khatuni appears on behalf of the respondent numbers 1, 2, 3, 5, 7, 8, and 9. Mr. A. Solia appears on behalf of the respondent number 10. The learned counsel appearing on behalf of the which department?
Secondary education, madam.
Secondary Education Department 6 for an accommodation. So that 6 for an accommodation to obtain the instructions in terms with the order dated 17/3/2023. List the matter again on 10th of May 2023, on which day the respondent elementary secondary education department shall apprise this court as to when the area salary would be paid to the petitioner, if so entitled. It is made clear if there is any delay thereafter, this court may consider imposing interest upon the
Obliged.
32.
Here I need some accommodation today, my lord, to get the entire instruction. So while fixing the pension, my lord, they wrongly fixed a wrong date, my lord. From the date of initial appointment, it was fixed.
overdrawal.
Over there, that's why there is overdrawal. Wrong fixation or wrong on the date of appointment itself, on the time that the pension was. So ultimately, the director of pension has submitted back. It should have been from 2004. So in the appointment condition, there was a condition he had to file, he had to clear some examination that was cleared in 2004 within 3 years.
But then
What status now, my lord? Because we have to read
Director
everything.
of pension has informed you almost 6 years back.
No, my lord, that
Yes.
page number 23, my lord. It is 6/1/2023, my lord.
No, no,
Yes.
this was what has been given by the Director of Pension on 6/1/2023. But you found out that there is an overdrawal earlier. Why
Lord,
did
there-
that happen now?
Then subsequently, my lord, that page number 23, my lord,
See,
because of the notice.
kindly come to page 18.
Lord. Page 18.
He was appointed as stipendiary teacher on so and so. Although he had passed the basic training on so and so, he was allowed to draw scale of pay from the date of joining, that is 99, ignoring the conditions of the passing the basic training. In this connection, specific views of the government and the director of so and so is required. This was given in the year 2017. Then you have given something to that effect, and by which there is a amount of overdrawal of 3,79,000.
3,79,000.
Then there is another letter written by Swen in
6/1.
on 6/1/2023. It is after 7 years.
Lord. There is less, my lord.
But the
Let me get the-
petitioner have not got. Have you got provisional
Provisional
PCRG?
other benefit is not.
No, let me get the instruction. Short date, my lord.
When?
What will be clear? No, in the, let it be on the last week of April, my lord. In the meantime, I will get that instruction.
First week of
But last week of April.
Mr. P.K. Das, the learned counsel appearing on behalf of Mr. P.N. Sharma appears on behalf of the respondent number 1. Mr.
I appear for as well. Okay, for 2, 3, 4, and 5.
S. Bora appears on behalf of respondent number 2, 3, 4, and 5. Mr. S.R. Pulva appears for respondent number 7.
6 and 7.
7, huh?
6
6
and
and 7. And Mr. R. Porpudari appears for respondent. Mr. A. Solia appears for respondent number 8. Mr. S. Bora, the learned counsel, appearing for the respondent number 2, 3, 4, and 5. 6 for an accommodation to take instructions in terms with the order dated 17/6/2023. But the matter be listed again on 3rd of May 2023. In the meantime, the council appearing on behalf of the PTC as well as the director shall on the next day the council appearing on behalf of the PTC as well as the Directorate of Pension shall apply as to when the petitioner's pension will be finalized.
But if we are yet to receive the extra copy from the petitioner.
Oh,
Here,
no,
I have
No,
the
no,
receipt
Lordship.
from the clerk, Lordship. Then he has
Not
filed-
so lot.
I don't know, Lordship.
May-
Okay,
I'm ready to
today
with
itself,
my
No, I have
if
received
not
it.
got Lordship,
I'm ready with my letter, but not received the extra.
my client has given me Lordship. This clerk says-
understood, Mr. Dad.
Obliged, Lordship, I have
Do the needful.
Lordship.
I don't like to
Within an
put all
hour.
these things on record.
33.
Anyway, the live streaming is going on. Apart from that, I put it on record.
My pleasure, Lordship.
May I
Yes.
please, Lordship? We have communicated
Ah,
with the department. Department requested for 1 week more time, Lordship. Instruction not received. On behalf, I am appearing on behalf of pension department.
okay. Oh, that matter.
Yes, your Lordship.
Yes, Lordship.
6 years.
So,
14
she-
years,
This
14.
14 years was not,
Yes,
yes.
shall
Deducted.
obtain the insurance as to why 14 years, 7 months,
Yes,
Yes,
4
sir.
days was excluded.
yes, Lordship.
Why? Why have
1
you
week
done that?
more time required, Lordship.
We'll have it on 10th, 12th. On 12th. Let him have a good bihu
Yes, Lordship.
at the request of Ms. S. Purva, the learned counsel appearing on behalf of the petitioner, respondent number
2 and 5.
2 and 5. time is granted till 12th of April 2023, on which date the State Council shall apprise this court in terms with the order dated 23/2023 passed by this court. Which liberty is given to the petitioner to mention the matter for upgrading.
Highly obliged,
Madam,
Your
this is the old matter. He's how much old? What is your
78,
age?
78 years.
See, 78 years is fighting an
We have forwarded up.
34.
Highly obliged.
Oh, and appears for the petitioner then also today. Yes, any further amount is entitled to?
Finance department.
So finance, yes, finance, tell me. So this matter, he has left the brief. He is like here. Tell me, is he entitled to any further amount?
Lordship, here we
On the last occasion, it was mentioned that provisional pension has been 5,84,000 has already been paid to the petitioner's husband. And accordingly, DCRG payable would be rupees 43,064. You are also directed to find out as to whether the petitioner is further entitled to any other amount. Because what he has claimed for
Lordship.
is for service benefits of the petitioner's husband, including leave salaries, GPF, and GIS.
Yes, Lord.
Any instructions?
Lordship, here we have misplaced. We don't have an updated instruction, Lordship. Lordship may grant me some time, Lordship, because we have missed out on this matter, Lordship. I apologize, sir.
Find it out.
Lordship, I'll find out, Lordship.
Don't go as per what the petition, because of the petitioner counsel is not there.
Yes, Lordship. We will get the up-to-date status. Madam.
Let us do some justice in absence
Lordship,
of the
Lordship.
Mr. Azolia, appearing on behalf of the Finance Department, submits that he requires an accommodation for a week to obtain the instructions in terms with the order dated 17/3/2023 passed by this. List the matter again on 12th.
Lordship, any date?
On 12th.
Lordship.
Just find out this.
Yes, Lord.
Any other amount.
1 at 3 and 4.
Madam, you are going to find out any further thing?
Lordship, let the respondent find out, Lordship. Respondent jointly, Lordship, if any.
Mr. Purva and also seeks an accommodation. Mr. Azolia and Mr. Purva. Mr. Purva seeks an accommodation for a week to obtain the instructions in terms with the order dated 17/3/2023. List the matter on 12th, but on which date Mr. Purva as well as Mr. Azolia shall apprise.
35.
Yes. Tell me what you want.
I got an amount of 2,90,235 has been recovered from my death cum retirement gratuity after my retirement.
Oh, yes. Higher education. No higher education council. And last time we have also put them to notice that interest would be claimed. Yeah, we have direct the higher education director to appear.
Well,
Better.
Mr. Kegogo is coming. I have informed
He's
him.
not there.
He's coming.
Then
I have informed him.
to appear him to appear.
He's coming.
Yes, Mr. Gogoi. What instruction you have got?
35, Lordship. Item 35.
I hope so. 719.
719, please.
Who paid this amount of 2,95,90,000?
Lordship, it was from the government exchequer due to the Lordship that was done by the DDO Lordship. DDO in favor of the petitioner Lordship.
Huh?
DDO has passed the bill Lordship in favor of the petition. DDO is the principal of the college.
Then
Lord.
that amount has been refunded to the petitioner.
Lordship, that amount was deducted from the discharge Lordship, that amount.
And then deposited into the treasury.
Lordship, Lord.
Then he is entitled to the amount. He is entitled to the amount. It is your fault. Now have the pension been regulated as per the properly?
Lordship.
So only we set aside this directive for refund of that amount.
Lordship, it will be refunded by the Lordship as he has deducted in source Lordship.
Who?
As he has deducted in source Lordship. Page 29 Lordship may kindly peruse Lordship.
Accountant General. Who is
Lord.
paying for the Accountant General? Is he a party?
Yes,
sir.
Ah, Accountant General party. Okay. The payment will be made by the Accountant General. Where is the Accountant? No Accountant General. Okay, let us see. By the time if he doesn't come, we'll see. Let me pass the order. What, Mr. As the learned counsel appearing on behalf of the petitioner, Mr. K. Gogoi appears on behalf of the respondent number 1,
Lordship, I am for 1 and 5 Lordship.
1 and 5. Mr. Any finance? No finance. Okay, anyways, we put the finance out there.
And
Mr.
Lordship, yeah, next also I have the given instruction Lordship. That is a treasury receipt is there, whoever petitioner has Lordship refunded the amount. I don't know, kindly press for a moment Lordship. Then Lordship may direct the authority also to refund the same if Lordship desired Lordship.
This has been given to the treasury officer,
are-
name and address
Lordship.
of the
And
person on whose behalf money is paid.
and head of the
That is
account is
treasury man.
head of the account is there Lordship.
Head of account is given
Lord.
2021019. What is this? Who has deposited this? This is received by
This
the
is
treasury.
deposited by the petitioner Lordship.
Huh?
This is deposited by the petitioner overdwell amount, Lordship. For,
No, you are saying that this has been deducted at source.
my Lordship, kindly give me, I will verify. Lordship, after 5 minutes, I will exact position, Lordship.
Okay,
Exact position. Lordship.
we have it after 5 minutes. We'll have it as the last item of the day.
Lordship.
Wait. Yes,
Yep, is a Lordship, as per last office note dated 29/3 method, the service upon response number 3 is complete.
respondent number 3, that is. Respondent number 3 is complete. What
Okay.
are you asking?
Well, my case is for non-payment of the pending salary, pensionary benefit, subsistence.
Oh, by the Howley.
Howley method.
Without Howley, how do you bring in this thing? Effective implementation. By area salary, na?
Pending salaries, pensionary benefit, subsistence.
Who is appearing for municipal administration? Urban Development Department.
P9 appeared for our UDP and municipality administration, we can appear.
Where is he? Not there. They have nothing to pay.
Yes, they have already.
It is only the Howley
Howley.
who has to pay. Howley Town Committee is a area of what you have not got.
Well, the area salary, subsistence allowance, pensionary benefit,
Retirement dues, pensionary benefits, nothing.
nothing.
Okay, we do one thing. We keep it after vacation. We'll pass orders. If they have not, I won't record that. Heard Mr. G. Bharadwaj, the learned counsel, appearing on behalf of the petitioner. You are appearing? As Guru
Yes,
appears
for
for respondent
respondent
number
number
1
two.
and 2. None appears on behalf of the respondent number 3. It further appears from the order of the Lozima Court dated 30/3/2023 that the service upon the respondent number 3 was duly affected by way of the state. And as such, the service, taking into account the service upon the respondent, that the matter be again listed on 28th of April 2023, on which date an attempt shall be made to dispose of the petition.
Highly
Liberty is given to the petitioner to mention the matter.
37.
Legal heirs of the original writ petition are pursuing the claim for
Is
relief.
a hearing matter?
Lordship,
Who's it?
hearing matter, but Lordship, the Honorable Court had fixed it.
April?
The other day when the matter came up, the. Honorable
What is
Court
this
was
matter about?
concluded- Yes, the original, the legal heirs of the original writ petitioner are pursuing the claim for release of provisional pension to the deceased petitioner. The issue is whether the deceased petitioner will be entitled to provisional pension post conviction during the pendency of the criminal appeal. That is the issue. It's covered by a judgment of Honorable High Court. Therein, Lordship, the Honorable Court had held that during the pendency of the, as it is, the appeal is the continuation of the trial. During the pendency of the appeal, the petitioner, the one will be entitled, employee will be entitled to the provisional pension. Because unless and until the appellate court pronounces, adjudicates upon the order of the judgment of the trial court, takes a decision.
22-1.
Yes, 20, that will be deemed to be continuation of the judicial proceedings. Because the section 22, rule 22 of the pension rule says that during the pendency of the judicial proceedings or discipline proceeding, one will be entitled to provisional pension. Now, herein, no doubt the trial court had convicted the petition, the deceased petitioner, but thereafter we had moved the appeal and it is admitted it's still pending for final hearing.
You are still in jail?
No, he has died. He was out on bail. He was enlarged on bail, and after that he passed away. And that is the only issue. The judgment we have already placed.
Your
its own
Lordship,
record.
conviction is still in the field, Your Lordship, it is not
Huh?
suspended. Conviction is not stayed, Your Lordship. Only sentence was stayed, Your Lordship, and even in the appellate court, that is not pleaded. Conviction was not, for a stay of the conviction, it was not pleaded. So, Your Lordship, the authority is rightfully, I mean, legally, Your Lordship, withheld this pension. Your Lordship.
Conviction has not been stayed.
Yes, Your Lordship. On this sentence.
Now, has the governor passed an order under 21 that
Yes,
is
sir.
not entitled to pension?
Yes, yes, yes.
Where is it?
That page number 32, Your Lordship, of the writ petition.
30?
32
Yes.
of the writ petition.
Where is the order under 21? Rule 21, that the governor says that he is not going to pay.
Yes.
Pension is hereby accorded to the drawing of provisional pension. You are claiming provisional pension.
Provisional pension.
Then
Your Lordship, since he has been convicted by the trial. court,
understood.
And there is,
Don't you think that once a person is convicted,
yes, sir.
you are to take action under 21?
Yes, sir.
Have you taken that? Because you can't deprive the pension. It is only the governor who can do. Maybe he will obviously delegate, but it has to be under the orders of the governor.
The judgment which I'm relying on, it is there on record.
Lordship, the order was issued by the government, Your Lordship. But
Where?
the Annex 6, page 32.
Annexer
6, page 32, Your Lordship.
6.
6.
Page
Page 32. That order was issued by the government.
No, where is that order that you are not going to? Unintentional jail prescribed with effect on actual date of conviction dated when Hence, he is not entitled
Right,
for
Peru,
pensionary benefit.
pension penny.
The incumbent retired from service. Oh, how can you do this? I was passing an order of this type. This has to be done under 21.
Yes, yes,
Then these are orders under the governor.
yes.
Yes, what judgment you are
Lordship,
referring to?
Yes, Lordship, so far as to Rule 21 is concerned, that is with regard to regular pension. And there is also Rule 22.
No, no, no.
Yes, post-conviction.
What I
yes.
am saying is that Rule 21 is entitled. Rule 22, you are entitled to provisional pension.
Yes.
You keep on being entitled till there is a conviction. Now, if there is a conviction, that is Rule 21, you can stop it. But this has to be under the governor, orders of the governor.
Lordship, may I just interrupt? It is not conviction. Word use is not conviction. It is use finality of the judicial proceeding. Judicial proceeding. That is why this whole issue has arisen, because they have interpreted it that conviction is the finality of the judicial proceedings, which is not so.
No, no, no. Madam, I'm not saying that. I'm saying that you see, the power under Rule 21 to withhold the pension
Yes, the
is given only to a governor, not to anybody else.
Yes.
Now, where is the order of the governor? That is what I'm asking him.
Yes, the Lordship has correctly raised that.
So that is why this
yes.
pointed query,
Yes.
as regards why, how can the commissioner and secretary or to the panchayat and well say that no, I'm not going to? No, he can't. It is the power is only given to the governor.
Governor for withhold. Yes.
The governor has not acted upon it. How can they withhold? Forget about any pension, the provisional pension you are entitled to.
Yes. Yes.
Yeah, what do you say? The incumbent retired from hence he is not entitled for pensionary benefits. How can he do that?
That cannot be. Yes. Yes.
It can't be at the instance of so and so. Apart from the fact that it is an appeal which is a continuation of the proceedings.
Lordship, the judgment.
Yes.
Lordship, this judgment referred by my learned friend, Your Lordship. The factual metrics different, Your Lordship. In that case, Your Lordship, the appeal against acquittal. He was acquitted by the trial court, and subsequently the state had filed a appeal against acquittal, and it was appeal was allowed.
He was convicted.
In our
What
case,
is the
Your Lordship, the
judgment?
trial court
What is
convicted.
the judgment of Justice Sanjay Kishan Kaul?
Yes. Therein also, Lordship, there is a observation that appeal is the that was with regard to release of DCRG, whether during the after the culmination of conclusion of the judicial proceeding, DCRG can be released during the pendency. Therein the appeal was pending, whether during pendency of the appeal, the DCRG could be released or not. That was the issue. Here, DCRG cannot be released even though provisional pension can be paid during pendency of appeal. That is what the statute also says, that DCRG cannot be released. That was the issue there. If your lordship peruses para 39 of that judgment. Paragraph 39.
So here the case is the other way around.
Yes.
The state has filed an appeal against the Kerala, full bench of the Kerala High
Yes. Yes.
and it was observed to the effect that an appeal is being a continuation.
Continuation of the
So then the state can very well withhold it,
withholding.
withhold the DCRG till then. Because the question was as regards the DCRG, can it be released
Yes.
pending a
Yes.
proceeding?
A statute itself provides DCRG cannot be released till conclusion of the final judicial proceeding.
Okay.
So, Lordship, the ratio, also the observation that para 39, which was referring to, appeal is a continuation of the trial. So, the conviction does not end the judicial proceedings. Herein, as it is the appeal is pending before the Honorable Court. So, it can be said that the with the conviction, our judicial proceedings has not culminated. So, I am entitled to provisional pension. That is the issue. And the judgment which I'm relying on, the judgment passed in WPC 1782 2004, no difference in text. The appeal was against acquittal, no doubt that is admitted, but against that acquittal was set aside. So the conviction, he was convicted. Thereafter, therein the petitioner, he had prepared an appeal before the Honorable Apex Court. So because the appeal was pending.
Okay. Don't worry. Your case is going to be allowed. Heard Mr. T. Borgwai, learned counsel appearing
Your
on
Lordship,
behalf of the petitioner.
Your Lordship,
And
we'd like to rely on a Supreme Court judgment, Your Lordship.
yes,
Ramanarang decision.
very well. Give it to me. And Mr. K. Poon, the learned counsel appearing on behalf of the PNRD department.
Your Lordship, the conviction is to be specifically suspended. Otherwise, he will be disqualified. Paragraph 12, Your Lordship, we are relying on 12, 14, and 15. Citation 1995. I1. Our judgment, Your Lordship, on the same point.
What is the power to grant a bail in a criminal proceeding?
Yes, Your Lordship.
What is the power? Under what power does the court grant the bail in a criminal proceeding?
15 and
In April 389 CRP, section 389 CRP.
Yeah,
389(2). then has the two parts, Your Lordship. One is the conviction, another is the sentence. Here only sentence is suspended.
Therefore, the moment a person is granted bail under 389,
Yes, Your Lordship.
just for example, a person is convicted,
Yes.
but he is otherwise outside. Then the question of bail does not arise.
Even then he will have to approach the next day appellate court for seeking bail, Your Lordship.
No. Whatever may
Stay
be,
of the suspension or the
because
conviction,
if you
whatever
see
it
the
is.
language under 389(1, pending any appeal by a convicted person, the appellate court may, for reasons to be recorded by it in writing, order that the execution of the sentence or the order appealed against be suspended. That power is given.
Yes.
And also, if he is in confinement, meaning thereby that there is a scope that he may not be in confinement, he be released on bail or on his own bond. Now, if a person is released on bail, isn't that the consequence of a suspension?
Yes, Your Lordship, that is Your Lordship, the conviction, when the conviction is given, it cannot be executed automatically without giving sentence, Your Lordship.
No.
Punishment will
Here
have
the
to be given.
sentence has been given.
Yes,
Obviously, the moment it has happened, the sentence has been given.
yes,
Now, once the sentence is given,
yes, sir.
without staying it, can he be sent on bail?
Here it is a state.
Because what you are referring to, that judgment,
Yes, Your Lordship.
is that mere filing of an appeal
Yes, sir.
could not
Yes,
ipso facto be. But here is a case where he has been granted bail. Can a bail be granted?
yes,
That is why I asked. I normally a bail is otherwise granted under various other provisions.
yes, sir. Here-
437, 436, 439, so and so. But in appeal, a bail is granted under 389.
Yes, 389 2 under 2. Your Lordship. Your Lordship, they kindly see this in the after conclusion of the trial, Your Lordship, the first becomes the conviction.
Satisfies the court by which he is convicted, he intends to be present at the appeal. No, therefore the question is, if 389 is the power on which a person
Yes,
is to
yes,
be
the
released
court
on bail.
has the power.
No, if the court has to be, I'm not saying that the court doesn't have the power. No. Isn't the granting of a bail preceded by an exercise, may not be written out there, that this sentence has been stayed? Otherwise, what will have impact? Only appreciate.
Your Lordship, yes, suspended.
A person is being given bail.
If the bail is given, that means, Your Lordship, suspension sentence is suspended, but not conviction. Conviction will remain. If the specifically court says the conviction is also suspended, for the time being, then, Your Lordship, conviction will be suspended.
Where is the conviction to be suspended? Under what provision?
Lordship, he is right in that respect. Conviction, unless and until the conviction is specifically not stated, then under 389(1), either the conviction or the both can also be stated, or only the sentence can be suspended. Here in my case, the sentence has been suspended. Conviction has generally, Lordship, the conviction is not kept suspended. Only in very that is what the Honorable Appeals Court has also laid down.
So here, therefore, there are two aspects.
Yes.
Order that the execution of the sentence.
Yes.
Yes.
Or the order appealed against.
Yes.
Suspended. The exercise of the bail, exercise of the jurisdiction for bail,
yes,
is only upon the exercise of staying the suspension order. Staying the sentence.
Sentence, not the Your Lordship, the conviction, until and unless the conviction is interfered with or is suspended by the appellate court, then he will be treated as convicted. And in their case, they have not pleaded even for a stay of conviction.
No, it is not necessary here.
It is necessary, Your Lordship. There are so many decisions, Your Lordship, and he was convicted under the PC Act, Your Lordship.
Lordship, what is probably I haven't gone through the judgment. That is necessary in case of in-service persons who are in service. Because if the conviction is stayed, then the employee concerned, that the accused concerned, he can also apply for reinstatement in that case. But in this case, what the issue is here, whether with conviction.
Madam, conviction, staying of conviction is in very rare cases.
Yes.
Very rare.
Case.
I still remember it was a case of Navjit Singh Sidhu, where the Supreme Court had stayed the conviction, not the sentence. The reason why, and that is the reason why this happened in sometime in 1988-89. Because of the staying of the conviction, he could roam around with his passport and go and play for India now at that point.
There is another judgment, Your Lordship.
Their judgment relates to
of Madhya Pradesh High Court, Division Bench judgment, Your Lordship. Yeah, it's up to particular, definitely. Your Lordship, it covers our case, entirely covers it. Same facts, Your Lordship, similar facts.
No, but that is one aspect.
Yes.
Can the commissioner exercise that power? Madam is not putting that question. That is the most crux.
Yes.
The power is to be exercised by the governor. Then how can you withhold the provisional pension or any?
Yes.
Because Rule 21 starts with that.
Yes, Your Lordship, governor has the power, Your Lordship. Then we will have to see that how decision was made, Your Lordship.
No, it has to be, the order has to be in the name of the governor.
Definitely. 21.
So Rule 22.
21, Your Lordship, under 21 it is different.
You see, Rule 22, let's read Rule
Yes,
22.1. Where any departmental proceedings or judicial proceeding is instituted under Rule 21.
Yes, sir.
Or where a departmental proceeding is continued under Clause A of the proviso thereto against an officer who had retired on attaining the age of compulsory retirement or otherwise, he shall be paid during the period commencing from the date of his retirement to the date on which, upon conclusion of such proceedings. Now, it is not on conviction. Final orders are passed. A provisional pension not exceeding the maximum of so-and-so, and if he's under suspension of so-and-so, but no gratuity or arrears shall be paid under so-and-so, shall be adjusted against the final so-and-so. Now, can you say, here the question is not of conviction, here is a question of conclusion. Can you say it is a conviction? Unless you exercise 21.
Yes. Your Lordship, here, Your Lordship, since the conviction is still in the field, Your Lordship.
Understood. But 22 does not say conclusion. It says conclusion.
Yes, yes.
Now the conclusion will include the appeal also. Conclusion, because it has not been concluded. The moment an appeal has been given, the appeal will go on. But 21 gives you the power to withhold, whether permanently or for a specified period, the right of ordering the recovery from the pension or whole of this so-and-so if in a depart or there that is found guilty of maid or negligence during the period, including service rendered under re-employment and after retirement, provided that so-and-so.
Even the legislature has refrained from using the word conviction in Rule 22. So
that is what I'm saying.
Yes.
I'm only saying about conclusion.
Yes.
Can you say it to be concluded when an appeal is pending?
But your lordship, the
unless you exercise 21.
yes, your lordship, we are empowered under 21. Your lordship, since the conviction is there,
Understood. Conviction, you say it is there. Very well, you could take action to that effect, but it has to be under the aegis of the governor.
yes, your lordship. Into that part, your lordship, let us bring specific instruction, how the decision was made, your lordship.
Clearly, this is not a order which has been passed under Rule 21.
Absolutely. That
Yes.
is what I'm saying. This order by which you have been stopped from getting your pensionary benefits is by the commissioner. It cannot be by the commissioner. It has to be under the aegis of the governor. Yes, the governor delegates the area, but that is why the orders are normally passed by in the name of the governor.
Yes, sir.
This is how it is normally done. In many cases, all whatever it is. That is not being done out here.
No.
So under such circumstances, if 22 does not say, doesn't say about conviction, but conclusion, obviously there is no conclusion as of now.
So far as trial is concerned, that is concluded.
Huh?
So
No,
far
no,
as the
the
concerned,
trial
that is
cannot be concluded when an appeal arises.
Yes. Your lordship may kindly see the Rule 24 of the pension rules for a moment. Your lordship. No pension may be granted to an officer dismissed or removed for misconduct, insolvency, or inefficiency, but the officer should dismiss or remove compassionate allowances or public and land compassionate gratuity may be granted when they are deserving of special consideration, provided that the allowance of the gratuity granted to any officer shall not exceed 2/3 of the pension gratuity, which would have been admissible to him if he had retired on medical certificate.
How is this
Not-
relevant?
This is not applicable to me because I was removed. The removal has been set aside by the Honorable Court.
No, your lordship, the death, death,
No, let us not transgress into further foreign territories. Here is a case, therefore, can you say it to be without an order under 21? Could you have said that this you have done this?
then your lordship, the specific instruction will be required to how this decision was made, your lordship.
It is lordship, the order has to be just from the what appears on the face of it. They cannot now say like this is how this was done. Order itself, order will have to reflect what was the decision or reasons behind like passing of the Lordship Mohinder Singh Gill.
No, they can't improve on that.
Yes.
There's no quarrel with that. Let us see what they do. We'll have it on 11th. Ultimate Steve of Learned Council appearing on behalf of the Learned Council appearing on behalf of PNRD department.
Yes.
Hearing the matter at length, the counsel for the PNRD department admits that you would like to take instruction as to whether the order impugned in the instant proceeding is an order under Rule 21 of the Assam Services Pension
Pension
Rules
Rules.
1969. This is the matter again on 11.
Oblige.
Item 40.
Yes.
On the last occasion, 17/3/2023, Lordship, was directed to take justice upon the response number 4, and accordingly, we have taken the justice.
So yes,
Yes, I have filed the affidavit for response of 4 million. We have issued that royal and non-royal certificate in terms of the order that 76.
Oh, yes, the headmistress.
My lord.
Why you are not issuing that?
My lord, I have also explained the position, my lord, that outgoing headmaster, he has not submitted any document to the present, my lord. The audit report, that case book, that passbook of the school, my lord. Everything is in his custody. my lord.
Lordship, there is a specific instruction from the treasury officer.
Yes, Mr. Counsel. He has already submitted the non-royal certificate.
My lord.
Why haven't you appeared before the authority? Didn't I ask you on the last occasion? Yeah. It's a specific, the petitioner is also directed by the instant order to visit the treasury officer for verification of the specimen signature and for identification of the petitioner as per the descriptive rules and furnish such other details so sought for by the treasury officer. Why haven't you gone there? You want the court to take up this matter on an urgent basis, and this is the state of affairs of the petitioner. He's negligent. Royal non-royal certificate has already been submitted by Srimati Akoni Borua. Who is Akoni Borua? Oh, no, by the principal.
Yes, my lord.
Headmistress of Duliajan Utsav Vidyalaya.
Yes, my lord.
On 27/3/2023. Then why haven't you gone? Should the court carry you, Mr. Counsel? Then
We'll go there.
hey, this is not interested. You are not interested. We'll have it in the way, admit the matter, issue rule, and have it after 10 years. This court have taken the matter urgently, and this is the state of affairs.
We will visit after tomorrow.
Out Mr. K. Kolita, the learned counsel appearing on behalf of the petitioner. Mr. A. Sonia appears on behalf of the Treasury Officer, Naharkatia Treasury. And Mr.
P. Hazari.
P. Hazarika appears for the response number 5. 4. Mr. A. Sonia has submitted that had produced an instruction by which it has been reflected that the Treasury Officer, Naharkatia, by which it is mentioned by the Treasury Officer Naharkatia that the royal and non-royal certificate of the petitioner have been submitted by the headmistress of Duliajan Utsav Vidyalaya Duliajan on 27/3/2023 by letter dated 27/3/2023. However, the petitioner had not appeared before the Treasury Officer till 31/3/2023, along with other necessary documents as previously mentioned in the letter dated 15/3/2023, which have already been dispatched for claiming his pension. This court further would like to take note of that in the earlier order dated 17/3/2023, this court had specifically directed the petitioner to appear before the Treasury Officer Naharkatia for verification of the specimen signature, for identification of the petitioner as per the descriptive rules, and also to furnish such other details so sought for by the Treasury Officer Naharkatia. However, it seems that the petitioner is not interested. So taking into account the same, let the matter be listed after 4 weeks.
Lovely.
Item 22.
In the meantime, the petitioner shall take the necessary steps. Yes.
This is my lord, regarding non-payment of salary with effect from my lord 1 on 2021 to till date.
Yes, Mr. Sharma, why
Lordship,
no?
Lordship, I have a telephonic instruction, Lordship, that for payment, the process has been started. So they will be making the payment because there was an earlier litigation out of which there was an inquiry report. And that
Mr.
inquiry
P. N.
report,
Sharma, the learned counsel appearing on behalf of the Elementary
Elementary
Education Department submits that the steps are being taken by the concerned respondent of the department for the purpose of processing the area salary of the petition for the period from
1/1/2021
to
till date. my lord.
till date. Let the matter be listed again on 8th of May 2023, on which date the learned counsel for the respondent elementary education department shall apprise the court as regards the status of the area of the salary of the petitioner, of the area salary of the petitioner, and what steps have been taken now for the purpose of paying the regular salary to the petitioner.
26.
Criminal proceeding already closed, Lordship. I have got the order copy.
What? Oh, you went to the court?
Yes, Lordship.
Ah.
but otherwise also there is a direction given by the director to the DO.
I
There are
think the
certain-
elementary to why they Mr. R.A. Ahmed, the learned counsel appearing on behalf of the petitioner, and Mr. P. N. Sharma appears on behalf of the Director of Elementary Education. Mr. R.A. Ahmed, the learned counsel, has drawn the attention to an order. I keep it on record.
Yes.
Order dated 27/3/2023, wherein the PRC, wherein, what is the case number?
927/17.
We are 341 of 2019.
Wherein the case PRC case number 341 of 2019, wherein an order dated 27/3/2023 in PRC case number 341 of 2019 has been mentioned. It appears therefore that in view of the death of the husband of the petitioner, the said proceeding, criminal proceeding, have been closed as abated. The order so submitted by the learned counsel for the petitioner is kept on record and marked with the letter Y. Mr. P. N. Sharma, the learned counsel appearing on behalf of the Elementary Education Department, has submitted that steps are being taken for the purpose of assessing the actual entitlement of the petitioner for which 2 further weeks' time is required. So taking into account, let the matter be listed again on 12th of May 2023. On the next day, the learned counsel appearing for the elementary education department shall obtain the necessary instruction in terms with the order dated 10/3/2023, and as to when the said amount to which the petitioner is entitled to will be paid or disbursed. The said document, that's the instructions so submitted by Mr. P. N. Sharma is kept on record and marked with the letter Z.
Twenty-seven.
Well, please.
Yes, Mr. Bora.
I filed my affidavit. Reply has also come, my lord.
Okay, we'll have it when?
We'll fix in another day, my lord. The thing is that there is a central scheme. Central fund has dried up, so the scheme has been full. Now, my telephoning instruction is today, my lord. There is a board called Project Approval Board. They have already sent to the central government the numbers of persons which still to be taken, still to have the fully equipped with the normal children. So the board tentative date of meeting by the central government has fixed on 14/4 this month. Tentative date. If that gets approved, my lord, another set of fund for the next year it will come.
So the fund will come, then they will remain.
Then the number of students, as to the number of the students, the fund will be allocated. Then they will continue. But as on date, there is no fund to pay to the.
These are under centrally
sponsored. Because as to the number of students, the fund will come 4,000 or odd rupees something.
They are students, no.
No, they are not students. They are education volunteers.
Education volunteers. Oh, yes, yes. That day somebody was telling me these educational volunteers, they are going to go everywhere and to see as to the people who have dropped out
here,
or the people who are regarding
out of school,
and people who are not studying.
And they have to be trained to the level of the normal school. After that training, they put it to the normal school.
And your educational volunteer aspect is very dangerous. Huh? You have some agreement. I was taking up another matter.
Yes, agreement.
Who is appearing.
There is an agreement. He has annexed an agreement, madam.
Yes,
reply.
I have
that has left.
First, it is the agreement has to be entered into on 1st of February, the last one, and it will end on 31st of March. But the select list is valid for 1 year. Okay. We'll have it when? 1st of May.
Lord.
3rd of May.
3rd of May.
3rd of May.
In the meantime, that funds comes, then everything.
You get it done.
Otherwise, covered.
But no covered with the. Are you getting a salary?
No, they will not get it. No funds are there.
What is your prayer? That you want to remain there, work out there.
Since the last 10 years, my lord, we are working, my lord.
Understood. But what is your right to work on the basis of a contract agreement? Education volunteers are all on contract agreements. And how can that right be exercised, or court can be one of the parties to that contract between both of you?
Scheme is continuing.
Since
scheme is continuing, my lord.
So what scheme is continuing is subject to payment. If the government wants, it is a different thing. But how can you have a permanency to that? Isn't that one of the terms of the scheme also, or even the agreement to that effect also, that there is no right which shall accrue upon you on the basis of this agreement for further period?
Yes, there is.
Then?
Yes, the next it. There is. That aspect has been, my lord, held to in the similar order. And 2 orders, my lord, I have.
We fixed the matter on 3rd of May. And you hope and expect this court doesn't take up any more pension matters. This is the matter again on 3rd of May 2023. on which date? Heard Mr. AFNU Mullah, the learned counsel for the petitioner, and Mr. S. Bora appears for the respondent number 2 and 3. It appears that it appears from the record that the respondent number 3, 4, 5, 6, 7, and 8 have filed their affidavit on 17/3/2023. The petitioners have also filed their reply on 29/3/2023. The learned counsel for the petitioner and respondent submits that there are certain developments which are going on, taking into account for which he seeks an accommodation, that the matter will be listed again on 3rd of May.
28.
Yes, Mr. Gustami.
Director of Economic Ethics today filed an affidavit.
Yes.
They have admitted the fact we are not getting the financial benefit since 2030 to 16. So we have retired from service. We have already retired from service, but we have been delayed promotion because of the authorities' lapse. That has been admitted now. And they have wrote a letter to the finance department regarding our entitlement.
That affidavit is not here, na?
No. Today at 12 o'clock we have it.
We will. Which department is this?
Director of Economic and Statistics.
Economic.
So
And the
finance
government is not there.
Finance department affidavit is necessary.
Finance has filed affidavit.
No, director has filed finance affidavit is necessary.
Necessary. Where is the finance? No finance. Okay. Heard Mr. S.K. Goswami, the learned counsel, appearing on behalf of the petitioner. You appear, Ms. S. Purva,
I am for
1 and 2.
1 and 2.
Ms. S. Purva appears for respondent number 1 and 2. None appears on behalf of the finance as well as accountant general.
D. Rava for accountant general.
K. Rava.
D. Rava.
D. Rava appears for the respondent number 4. It has been mentioned by Mr. S.K. Goswami, the learned counsel for the petitioner, that the respondent number 1 and 2 has filed their affidavit today. However, the same is not on record. Taking into account, let the matter be listed on 26th of April 2023. The registry is directed to tag along the said affidavit filed with respondent number 1.
39.
Oh, yeah.
Yes. It has come in the column of no steps.
Huh?
As per no steps, we are directed to take steps for respondent number 3. But as per 3 is represented by the standing council.
Why is the High Court dragged into the scene?
I have start copy upon
When?
on 30.
Steps complete.
Yes, Lord.
And what is the,
Sorry, man.
what you are filing affidavit?
Not so far as I am not prepared to file affidavit.
What is the case about?
The petitioner is serving as a Havildar in 3rd PTF battalion, a criminal case.
Madam, you are filing affidavit.
Extra copy we have not received.
We have served, Lord, but again I will serve. The service is completed.
You are suspended.
Yes, Lord. On the direction of the trial judge.
The operation of the order passed by the Hindi movie. You are challenging this order before in 226.
I'm yes, but
how will the 226 arise?
But that an excerpt for page 22, that suspension order by the.
Understood. Suspension is okay, but how can you challenge this under 226? Annexure 3.
Yes, Lord. That's true, Lord. That is challenged by a criminal revision.
You need to do that.
Yes,
Then
yes.
only I can touch your thing.
Yes.
I fixed it after on 26th of April.
Yes.
In the meantime, move and unlisted.
Perhaps they have to confine their relief to this second prayer, my lord.
Huh?
They have to confine their relief to the second prayer, my lord.
Which one?
Prayer number 2, the consequential, the
Order of
suspension order, my
suspension.
lord.
No, understood. But unless the first one doesn't go,
That
it becomes very difficult. No?
that's true.
Because I can't touch this order under 220.
No, there has to be revision.
That is the problem. Chalo. PP Dotto?
A bolo.
A Bolo. Heard Mr. A Bolo, the learned counsel for the petitioner. Mr. H.K. Das appears for the Guwahati High Court. Mr. S. Burua appears for the respondent number 1, 2, 4, 5, and 6. Is it so?
4, 5, yes, lord.
1,
2 also.
2,
2, 4, 5, and
4,
6.
5, and 6.
4, 5, and 6. Learned counsel submits that she is yet to receive the instructions in the matter. Taking into account the same, let the matter be listed again on 26th of April 2020.
Extra copy.
I'll.
Only that,
Yes.
unless you do that, let us
Yes,
stay
yes.
there.
Oblige. Highly obliged.
Timing item 35.
One more thing, sir, the name of SCGC may be reflected.
Because the registry is directed to reflect the name of Mr. H.K. Das appearing on behalf of the Guwahati High Court.
Highly obliged.
Yes, what did you find?
Lordships, it is in the source treasury officers deducted as per a letter issued by the Lordship SG page 29 Lordship. On the basis of the letter issued in page 29 annexure 7 of the writ petition Lordship,
Who has deducted?
treasury officers has deducted Lordship.
So the amount has been deducted by the treasury.
Lordship.
So the payment is directed to be made by the
No,
treasury.
Lordship. Treasury officer deducted it was Lordship deducted in the government pension head. So Lordship from the government side it will be refunded. Lordship.
Higher education.
Lordship may directed the respondent authority Lordship then everything in directed the respondent authority.
Your prayer is only limited to that, no? You want the money back.
Yes.
Money
Hello,
was
I'll dispose
deducted.
it off.
Money was deducted Lordship on the basis of page 29 Lordship. Page 29 Lordship.
Oh, yes, I see.
There is a direction to the treasury officer Lordship regarding Lordship column number 3 Lordship recoveries Lordship F column number 3 Lordship. And on the basis of that Lordship, treasury officer deducted the amount in the store
From the TCRG.
Lordship TCRG
Hello, I'll pass that order.
Lordship.
Today itself you get.
Lordship,
Yes.
Lordship, I am appearing on behalf of
नाम किधर है? नाम तो